And hang on.
Mr. Stradley,
Good to see you, sir.
always a pleasure, man. How are you? Happy Friday?
Too.
We're on. Agent testers. Logos, he recommended, on the surface. Oh.
Great. Good morning, Mr. McMahon. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Morning.
Good morning. On June 6, 2026, police were dispatched to domestic disturbance at a residence in Harris County, Texas. Officer made contact with complainant who stated her and defendant were in the process of a divorce and living in the same residence. Upon asking complainant to step outside, officer observed complainant's underwear were torn and pulled into pieces. Complainant stated they were arguing about chores. Complainant was preparing a bath while defendant was there refusing to leave. Defendant then used his hands to grab and pull the waistband of complainant's underwear up, hard multiple times, lifting her off the ground and tearing her underwear. Upon falling, this caused pain to complainant's left arm and groin area. Complainant stated she was unable to defend herself and there was redness on her left arm and waistline. Officers observed signs of intoxication. Defendant's speech
On
on the defendant. Defendant's speech was slurred and reactions were delayed. Defendant stated he had not put his hands on his wife in a year. The complainant also alleged that the defendant was intoxicated.
do you have a rip done?
Yes, Your Honor.
Does she want contact?
We would ask for no contact, Your Honor.
Judge, if I may, there was a mediated settlement agreement within court matters. The parties are going through a divorce there.
Sure.
And he's still living together, which is probably a mistake in hindsight. But there's a mediated settlement agreement, where they've got the custody of the kids patched out. I don't think a no contact is necessary. He's gonna have his own apartment, and they need to communicate because
I understand, I respect that, but I want to know what her position is first. So what I'd like to do is I'd like to have her reach out. I want to know what her wishes are, and I'm going to honor her wishes. If she doesn't want to have contact with him, then I'm going to order no contact. I am, Mr. McMahon, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming alcohol, and I don't care what the occasion is, I don't care what party it is, I will revoke your bond and put you in jail. You understand? This is not a revolving door. So if I have to put you in jail, there will be no more PR bonds for you. There's a protective order in this case. You need to get to know it. If you violate the protective order, they can file additional cases against you. You're going through a divorce. You have now picked up a criminal case, which is ripe for what? Leverage. You know what I mean? So it's probably a good idea to be on your tippy toes and be as good as you can, because otherwise it's just going to go very wrong for you. You know what I mean? You got a great lawyer here. Listen to your lawyer. Because you have one, I will waive your appearance. It is your responsibility to stay in touch with it. If you pick up a new case, you have any kind of weapons, contact at this moment, then I will revoke your bond. Until I know that she wants to have contact with you, I'm ordering you no contact for the time being. We can have them reach out a little bit later. We have a full court, so it'll take some time, but we can have them reach out a little bit later to see what she wants to do. Then I'll honor whatever wishes she wants. For the time being, no contact, no weapons, no alcohol, no dope. Got it? We'll have you sign a reset. You'll get with Ron free bond conditions and then engage. Pretty good.
Thank you, Judge.
Please. So, Mr. Stradley, I don't know if you want to wait a while, if you want to come back maybe Monday, it's up to you.
We can certainly not have contact for over the weekend.
Okay. I might, whatever you want.
We're already in communication, so that's
Okay.
we'll get that camera.
Great to see you.
Thank you, Judge.
The restriction that was on the lower.
Yeah, for the time being. Yeah. He's living elsewhere anyways.
Bottom of 10, Littlefield, come on up. Okay, go ahead and find that.
Yeah.
You mind bringing your client up? Oh, there she is. What was her last name?
Littlefield.
Littlefield. All right.
Bottom of 10.
Thanks. Good. All right, Ms. Littlefield, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On June 7th at 11:54 p.m., officer witnessed a car with an expired registration on a public roadway in Harris County, Texas. Upon performing a traffic stop, officer noticed glossy eyes and strong odor of alcoholic beverage from the vehicle. Defendant stated she did not have any alcohol, but officer noticed an open Cutwater alcoholic beverage and closed whiskey bourbon. SFSD were conducted 4 out of 6 HGN, 4 out of 8 walking turned, and 1 life stay was not completed due to a claimed medical condition. BIC was read and the defendant was needed to provide a sample of blood and warrant information.
Can you run her and say, see, how many DWIs do we have? And then does she have a license, please?
Her license is eligible, Your Honor.
Okay.
I see 1 prior DWI, but I'm rerunning for
How long ago was that?
2015.
2015. Okay, so you see any more DWIs other than that?
I'm rerunning her and she
Okay. Ms. Littlefield, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will test you. If I find that you're using, you will go to jail. No more PR bonds for you. Do you understand? Because this is a second offense, I'm now requiring you not to drive any vehicle unless it's equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, likewise, you're in violation of your bond conditions and you will go to jail. I'm sending notice to DPS in Austin so that every police officer in the state knows if they pull you over, whatever car you're driving doesn't have an interlock, they're going to take you to jail. Do you understand?
Yes.
Okay. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch. If he tells me he cannot get a hold of you, then likewise, I will revoke your bond. I don't know if you have a problem with drugs or alcohol, but if you do, now is the time for you to address it. Because if you don't, I will do it for you. And I promise you're not going to like the way that I do it.
Yes. I just see that 1 DWI out of Collin County on there.
Got it. Okay. All right, guys, have fun. We'll just have her sign the paperwork. Once you sign the reset and get your bond conditions at that point, you're free to go.
I'll stick it, I'll just go to the order. It's not.
I'll sign it. Just let them put it all in queue and then, or do they know? Is it standard?
It's the same.
Got it. I'll sign it.
It's the updated.
Okay.
Thank you.
Thanks. Great to see you. Happy Friday.
All right, Judge, next is bottom of 5 is Larda.
No, Your Honor.
Hi. Do you need a translator?
No, you.
Got it. Good morning, Mr. Esparza. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or $200 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On June 4th, 2026, officer was assigned to traffic crimes task force and working on street race / street takeover initiative and conducted a traffic stop in defendant's vehicle. Defendant was stopped for performing multiple donuts and reckless driving inside the parking lot. Officer observed defendant perform the donuts within 10 to 15 feet of other vehicles. The incident was captured on cell phone. Defendant understood and admitted to doing the donuts.
Does he have a license to drive?
Yes, Your Honor, it's eligible.
Got it. Mr. Esparza, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to participate in these types of activities again, and you're not allowed to drive unless you have valid liability insurance in your name. You must maintain car insurance. If you don't have it, then do not drive. That is also a condition of your bond. If I find that you do any donuts, reckless driving, racing, street takeovers, into jail you go. I'm going to make your bond high. There will be no more PR bonds for you. You understand?
Yes.
I will keep my streets safe. You endanger it, I'm going to endanger you. We'll have you sign a reset. I'm going to have you take a seat while I get your bond conditions. Once you sign it, at that point, you're free to go.
All right, Judge, next is top of 14.
So-
Morales.
Yes, Your Honor.
You speak English. I think you speak English. Okay. I'll be there.
Thank you, Liz. You're the best. Come on up. What is his last name? Ralph. What is his last name again?
Morales.
Morales. Mr. Morales, you're charged with driving while intoxicated. First offense, it is elevated to a Class A misdemeanor because of the high blow. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On June 6, 2026, in Harris County, Texas, officer was informed by another officer from a vehicle driving at varying speeds and all over the roads, almost striking a wall. Other drivers were flashing their beams at the vehicle due to the hazardous driving. Officer located the vehicle still being followed by the other officer on Becker Drive and eventually almost drive onto the median several times and swerving dangerously on the roadway. Traffic stop was conducted. An officer observed defendant to be the sole occupant of the vehicle and sitting behind the wheel. Officer observed red bloodshot eyes, thick slurred speech, and a very strong odor of alcoholic beverage from his breath. Defendant stated he had consumed alcohol and was unsteady on his feet. Standard field sobriety tests were conducted, 6 out of 6 HGN, 3 out of 8 walking time, and 3 out of 4 one-leg stand. The IC was red. Defendant provided a breath sample over 0.160 and 0.163.
Can you look just to make sure that there are no prior DWIs, please?
Yes, Your Honor.
Mr. Morales, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, then I will revoke your bond and put you in jail. No more PR bonds for you. Do you understand? This is not a revolving door. I'm not asking much. Just don't drink alcohol. Don't use illegal drugs, including marijuana.
This is his first DWI arrest, Your Honor.
Does he have a license to drive?
Yes, Your Honor, is eligible.
Got it. You must also maintain liability insurance in your name. If you do not have car insurance, then likewise, you're not allowed to drive. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Ralph. If he tells me he cannot get a hold of you, then likewise, I will revoke your bond. We're gonna have you sign a reset. You'll get your conditions, and after that, you're free to go.
Thank you, Ron.
Please,
Thank you.
thanks.
All right, Judge, next is Pablo 17 Portillo. Good morning, Your Honor.
Do you need a translator? Yeah.
Solo me después si te contestan en español. Contemos.
Mr. Portillo, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On June 7th, 2026, officer witnessed defendant crash his truck and then park on a public roadway. After making contact, officer said defendant did not make sense when he was speaking. Officer observed the defendant have red, watery eyes, slurred speech, an unsteady gait, and a strong odor of alcoholic beverage from his breath and person. Defendant became belligerent and refused to cooperate, reviewed as a death piece. Defendant stated, quote, "I want my wife and mom." The defendant was arrested and read DIC, and a blood warrant was executed.
Does he have any prior DWIs?
No prior DWI, John.
Okay. Mr. Portillo, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. There will be no more PR bonds for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you and you will be in custody for a very long time. Does he have a license to drive?
We do not have a license on Colorado. I'm looking in that fine. Yes.
Does he have a license to drive? You are not allowed to drive. I don't care what you have to do. You will sign an affidavit with me today promising me that you're not going to drive. If you do, I can have a contempt hearing every time and you can be facing 180 days in jail every time you drive. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, then likewise, I will revoke your bond. Do not consume alcohol. Do not consume illegal drugs. Do not drive. That's quite possibly the worst thing you can do. Do you understand? Okay, we'll have you sign all your documents. After that, you will be free to go.
Thank you, Your Honor.
Thanks.
All right, guys.
Happy Friday.
Bottom of three, Butler. Come on up.
Good morning, Ms. Butler. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 6, 2026, officer was dispatched through an auto theft at the Harris County, Texas apartment complex. Complainant observed a Facebook post advertising a vehicle for sale for $300. The post indicated the vehicle did not have a title and was not operational. Complainant contacted defendant and agreed to meet to complete the purchase. Complainant arrived at the location with a record to transfer the vehicle and take possession of it. Upon arrival, the defendant represented herself as the wife of the owner and stated she was the person responsible for completing the sale. Complainant stated she found the defendant to be credible and believed her without verifying ownership information. While purchase was going through, the defendant attempted to sell another vehicle at the same location for $2,500. Complainant saw this was unusual and did not purchase a second vehicle. However, had already paid the first $300 for the $300 to the first one and left the location. Officer advised defendant did not own the vehicle and had no right to sell it. As a result, complainant was unable to keep it. Defendant admitted to not owning the vehicle and stated an unknown individual approached her and offered her $100 to use her information and increase the sale.
Ms. Butler, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to go back to this location and not to have any contact with the complaining witnesses in this case. If you do, if you pick up a new case, I will revoke your bond, put you in jail. There will be no more PR bonds. Do you understand, ma'am? This is not a revolving door. Do you have the ability to hire a lawyer? Deputy I'm sorry. Deputy will give you an application for an appointed lawyer. I need you to fill it out, and then I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. Do you understand? Okay, please.
Judge, was that pretrial or state?
Not states. Yeah. Hey, Kobe.
All right, Judge.
Yeah, hold on, Victor. Hold on.
It's a BDR, Judge.
I know, but he's busy. So, Kobe,
Then inside.
hey, you want to give me your cell phone, and I'm going to do arraignments, and then I can reach out to you when we're done, so you don't have to wait.
Of course.
So just here.
I can pop back in. This is the only thing I got. So I'll pop back in. That's fine. But you can have my cell phone.
It's up to you. That way, I can just so you don't have to wait.
Thanks.
Yeah. Okay. All right. Ready?
All right, bottom of floor, Castillo.
Sorry about that.
Yeah. So just thank you. All right. You are Mr. Castillo.
Yes, Your Honor.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 6, 2026, officer observed defendant's vehicle make a wide left turn in lane 1, then make an eastbound turn. Officer initiated a traffic stop. When asked for defendant's Texas driver's license insurance, defendant seemed confused. Officer observed defendant to have red watery eyes, slurred speech, and a strong odor of alcoholic beverage from defendant's breath or person. Defendant stated he and friends were at a restaurant where he had 1 beer, then went to a gentleman's club where he had 3 beers. Defendant seemed to be in a dazed state while speaking to officer.
Seem to be what?
In a dazed
state.
Defendant also had an unsteady gait. Standard field sobriety tests were conducted. 4 out of 6 HPN, 5 out of 8 walking turns, 3 out of 4 one leg stand. Defendant refused to provide a blood sample. A blood warrant was executed.
What is a wide left turn and what traffic infraction is that?
All right.
So defendant made a wide left turn.
Well, that's conclusory. That's just in violation of what? Is there a traffic law that says you cannot make a wide left turn?
Yes, I don't know the exact. code.
Show me. Show me.
Yes. Identification code section 545.101.
Yeah, I'm looking at it now. B1. You're looking at B1?
Yes, Your Honor.
To make a left turn at an intersection, an operator shall, 1, approach the intersection in the extreme left-hand lane lawfully available to a moving vehicle in the direction of the vehicle. After entering the intersection, turn left, leaving the intersection so as to arrive in a lane lawfully available to traffic moving in the direction of the vehicle on the roadway being entered.
And Your Honor, the officer observed the defendant make a wide left turn.
That's not enough. I'm going to find no probable cause to go forward with your case, Mr. Cutzio. Please be careful, sir. All right? I mean, every day. You know what I mean? Really? Okay, please.
All right, Judge, bottom of 6, Hernandez, come on up.
You're Mr. Hernandez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 6, 2026, officer observed defendant traveling in the right shoulder, facing the wrong way on East Freeway.
She's driving the wrong way.
Yes, there was a minor crash where defendant had struck a concrete median at this location. Officer requested a record. Defendant stated he was driving on the freeway and took a wrong turn. He stated he was coming from Channelview, then from Frank's Pizza. Officer observed defendant had red glossy eyes, slurred speech, and a strong odor of alcoholic beverage from defendant's breath or person. Defendant was detained. The scene was moved. Defendant stated he was drinking at an Astros game, and a friend bought a beer for him, including 2 beers. The air sobriety tests were conducted. 6 out of 6 HGN, 4 out of 8 walking turn, and 3 out of 4 one-leg stand. Defendant consented to a breath test, then withdrew consent. A blood warrant was then executed.
Can you look, does he have any prior criminal history?
I don't see any criminal history, Your Honor, but I can rerun the CIC.
Okay. And then does he have a license to drive?
Running his license right now, Your Honor. Sorry, his license is eligible.
Okay, Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs, including marijuana. You're going to get tested. It's not if, it's a matter of when. If you test positive, I will revoke your bond and put you in jail. Do you understand? This is not a revolving door. If I have to put you in jail, there will be no more PR bonds for you. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If you do not have car insurance in your name, then likewise do not drive. You have the ability to hire a lawyer.
Yes.
How old are you, sir?
19.
What do you do for a living?
I would get these cuts.
Do you want to apply for a court-appointed lawyer? You don't have to. You can do whatever you want to do. If you want to go out there, this is a DWI. Timing is of the essence. Don't wait a month or 2 because really, get on it quick. If you have any issues, you can come back and we can talk, but don't just sit there and wait. You understand?
Yes, sir.
All right. I'm going to have you sign a reset. I'm going to have you get with Veronica for your bond conditions. And after that, you'll be free to go. All right. Please.
All right, Judge, top of 7, 40. Come on up.
Hold on. After this, just give a sec, because she might be having issues. Veronica, you okay?
There's a calling over my cheek.
There's a what?
But there's
A bug?
yes.
Get the hell out of town. I mean, really?
Physically, I'm fine. Emotionally,
Yeah. I know.
she's a legal way.
Let me reach out to the facility.
I can't believe would I help you better? I don't say.
Sure.
Judge, you said you would like to put off something.
Okay. Do you mind giving me, please? So did you say, what's your last name, sir?
Horton.
Horton. Mr. Horton, you're charged with aggregate theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
On June 1st, 2026, officer was dispatched to theft of business call at 7-Eleven in Harris County, Texas. Officer made contact with the loss prevention manager complainant who advised he conducted an internal investigation regarding cash shortages dating from February 12th, 2026 until June 1st, 2026. Complainant advised he reviewed store transaction records and surveillance and discovered the defendant was taking cash from customer transactions and failing to account for money through register. The total loss was $2,281.95. Defendant admitted to taking money from the customer cash transactions for personal use over a period of several months.
Okay. Mr. Horton, I'm going to find that there's probable cause to go forward with your case. You're ordered not to go back to any 7-Eleven whatsoever for any reason. If you violate these conditions, I will revoke your bond, put you in jail. There will be no more PR bonds. Do you understand, sir? Do you have the ability to hire a lawyer?
No, sir, no, I don't.
How are you supporting yourself?
I work
Doing what?
on Bruce Allen Construction. Bruce Allen Construction.
Okay, and what kind of money what kind of income do you have monthly?
I get paid every week.
That's great. How much are you making a month?
Sometimes like $700 to $800 a week.
Okay, so you're roughly about $3,500 a month.
Yes, sir.
Tell me why you can't afford a lawyer. We don't give out lawyers like it's candy on Halloween. You have to qualify being at the federal poverty guideline level, which is about $15,800 a year to qualify for one lawyer. You understand? Right. So I can have you fill out an application, but I need you to be honest. I need you to put how much money you got in the bank. I need to know who you have.
Sometimes we got work, sometimes we.
That's why I'm monthly on average, what you're making. I need to know. So who else you are living with, I need to know because it's based on household income. I will take a look to see whether you qualify, but be honest on the application. You will be swearing to it. I need to know what kind of cars you have, stocks, bonds, mutual funds, IRAs, money in the bank. I know you now make around $3,500. So if you put zero on that, I'm not going to find that it's true.
All
Do you understand? All right, come on.
Ms. Barlow?
All right, Judge, the next is oh, yes, so on the jail docket, top of 40, you found it out. Rivera,
First letter F.
Right.
Come on up.
Did he post his surety or did they give him a PR bond?
Sure, Your Honors.
Are you sure?
The surety bond in the deeds.
On this case, no. Are you showing that he's on two felony deferreds as well? Are those open?
Taking a look. Yes, Your Honor, it does not look like they have filed an MHA yet.
But they are still open.
Yes, they're 5-year deferred position dates from 2023.
So the terroristic threat, the violation of protective orders, the injury to a child, do they have any, are there any of the same complaining witnesses as in our assault case?
You look right now, Your Honor.
Shh. Mr. Rivera, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine.
Different complaint, Your Honor.
As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, I will revoke your bond and put you in jail. There will be no more PR bonds for you. You have already missed court once. If you continue to miss it, I'm just going to triple, quadruple, or quintuple the bond. You understand? You are on deferred for 2 felony cases. It's very possible they file motions to revoke. So it would probably behoove you to have a lawyer pretty quick. As a condition, also, you're ordered not to have any contact with the complaining witness in this case, not to go where they live or where they work. There's a protective order that has been issued in this case. Actually, can you file another protective order, please?
Yes, Your Honor.
I'd like to renew one today. I'm going to issue another protective order today that you are not to have any contact with the complaining witness in this case, not to have a weapon, not to commit an act in furtherance of an offense under section 42.072, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where they live or where they work. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
You do? Okay, we will give you time. I'm going to have you go to Victoria Center Reset. I'm going to have you take a seat. Well, actually, we'll have you meet with Veronica for your bond condition at some point. As you can see, we're pretty busy. We're going to have you take a seat. And then when they call your name at that point. So we do need a MOAB at some point.
Okay.
So they're going to have to refile it.
Okay,
So
got it.
I guess just,
That's it for arraignments for now, Judge.
okay.
Yeah, approach.
Yes, come on up, sir. Wow, that's it?
For now.
No kidding.
Good morning, Judge. I'm here. I represent, Ohana.
In jail or a bond?
It's for a bond, it's a post bond, supposed to be a line of race. He has a PRS that's already done, and he has a bond, so that's here.
Oh, so it's not on the docket today?
It's not on enough.
Got it. Okay. So let me get the cause number and let me give it to the state.
I got those numbers down there.
Do you got the cause number?
Yes, Your Honor.
I don't. Can I give you guys a cause number? Are you ready? It's 261-9939. Did you get it, Rob?
Yes,
Sorry.
Judge.
Do you mind bringing your client up?
I seen a motion for the state to add a significant bond, for, I think it's 25. And that they're suggesting, I was wondering, is it possible to lower his bond?
We haven't even gotten there yet.
Okay,
Let me do
okay.
probable cause first, just to even see if there's enough probable cause to go forward.
Yes, all right.
I got one. All right. You are Mr. Barahona. Sir, you're charged with, burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 24th, 2026, complainant stated that his vehicle was broken into and personal items were stolen out of it. The stolen items cost a total of $495. Officer reviewed surveillance footage from complainant of the incident. The video showed the video showed defendant approaching complainant's vehicle, opening and entering the passenger side, and using what appeared to be a light ring cell phone inside the vehicle. The vehicle is then seen leaving the scene. Officer reviewed additional surveillance images in the same street during the same time, which captured defendant's vehicle. Officer conducted a vehicle check on that vehicle and learned that the vehicle was registered to Enterprise Rental Vehicles. Officer contacted Enterprise and learned that the vehicle was rented to defendant.
Wait, what?
So, officers observed surveillance video of the vehicle coming and the defendant breaking into.
Oh, I see. So you're saying that the vehicle that he was in to go there was an Enterprise and they were able to verify that it's his Enterprise.
Yes,
Do they have someone seeing that he's actually inside
yes, Your Honor.
complaining with
The complainant had surveillance video which showed defendant breaking into the vehicle and looking through the vehicle using a flashlight.
Do you see them taking anything?
Taking a look at the videos, Your Honor.
You said something about $400.
Yes, there was personal items taken out of the vehicle, or complainant noticed personal items were taken out of the vehicle and the total amount for those vehicles total, was $495.
Okay. Mr. Barahona, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this location and not to have contact with the complaining witness. If you pick up a new case, I will revoke your bond and put you in jail. There will be no more PR bonds for you. This is not a revolving door. Do you understand, sir?
Sure.
Okay. Does he have any prior criminal history?
I'm running this criminal history right now, Your Honor. And Your Honor, he does have some prior history out of Florida, possession of cocaine from 2009, which was a 1-year deferred, a tampering with evidence in 2009, a criminal registration in 2013, and a DWI in 2017.
Is that the most recent at 17?
I'm checking right now.
What would you like for a bond?
I was asking for a reasonable bond or PR bond, because these charges or priors are about a decade old. My client is 17 years old. He's from Miami, Florida. He's not running. He came here to.
Do you live here in Houston or do you live in Florida? You live in Miami now. Okay. What do you think about a PR bond?
Your Honor, argue we leave the bond as it is at, or at 25.
I don't think there's a bond set now at all.
Argue we set the bond at.
Yeah, we have to set something. Okay. I'll set your bond at $500. I'm going to grant you a PR bond, Mr. Barahona, but like I told you before, this is not a revolving door. It is your responsibility to stay in touch with counsel. If he tells me he cannot get a hold of you, I'm going to issue a warrant for your arrest. And let me tell you, if I have to issue a warrant for your arrest and you're in Miami and they pick you up in Florida, it's going to get a long time for you to get you down here. You understand?
Yes, sir.
Okay. We'll have him sign a reset. He's going to have to wait a while to get the PR bond. As you can see, we're pretty busy. We're going to have bond conditions created for you to sign. Do not leave until you sign the bond conditions. Okay?
Thank you.
Yes, sir. Please.
State's bond conditions?
Yeah. Yeah, just no contact, no weapons, and no going back to the location.
Yes, Your Honor.
All right. Can you follow this?
Hi, Joseph.
Good morning, Judge.
What's up, buddy? Haven't seen you in a long time.
Yeah, it's doing.
How are things?
Been a bit.
Yeah.
Been better.
You okay?
Yeah.
Bionic,
I
but
hope today's the last day with the slang, so we'll see.
I hope so.
Judge, I've got a latte shine on the docket
Okay.
and wanted to discuss,
Is it a new case?
it's fairly new. I moved it back, I wanted to discuss the scram.
Okay.
He's got on his ankle. He's a network, he had it prior to DWI, but this was stemming out of an assault. I think the scram was ordered, but he's a network systems engineer. He works in the corporate office, business casual attire, and having the scram on there is a bit intrusive. I see.
I don't remember why we did it. There must have been a reason.
Well, somebody alleges that he was intoxicated. But there's nothing further. It was a conclusory statement. He's intoxicated.
All right. So what I'll do is I'll switch you to a portable device for now. And if there are no violations after maybe 1 to 2 settings, at that point, we'll take it off completely. But I want to know that we can trust him and it's goes slow. So I'll take off the scram once he gets a portable device after some time, come back. If there's no violations, then I'll acquiesce to you. Okay.
Don't talk to the judge about that.
Veronica. But as you can see, she's super busy right now. So it's going to be a while.
Okay, thank you, Joe.
Okay. On Shine, we're going to take off the scram once he gets a portable device. Okay.
Yeah.
I know you're busy. Just, did you see the bug again?
Yes.
Thinking bugs. I mean, really. I'm telling facilities that the bug's attacking you to get up here, so we'll see. All right, Kobe. Hey, bud.
Dimitri of our bid. So.
Guess who's back? Back again. Guess who's back?
It's explainable this time.
Miss Murphy, come up. This is now number 3. Please.
So looks like what's going on. She has a scram device. She went and got the scram. That scram device is supposed to be downloading continuously and sending it to them. For some reason that was not happening. So she needed to go do a download at pretrial. So they download it every 7 to 10 days. Obviously, she was told this thing will be downloading, but if it wasn't, they come in every 7 to 10 days. She did that on Tuesday, went and did the download. They did confirm there was an issue with the device, that it wasn't downloading, it probably should have been. They've given her a new, some device that goes with the scram or something, that would now allow it to continuously download. And if it doesn't, still has to go in every 7 to 10 days. Pretrial said they had a difficult time getting a hold of her in order to basically tell her to come in and get that downloaded. Said she got a new phone, something with voicemail. I've been able to reach her. Looks like she's been able to reach them now. I think the problem's been remedied. She certainly, I don't think there was anything on that report that said she'd been drinking. But I think it shouldn't be a problem now that she has this new, whatever the Wi-Fi devices they gave her for pretrial.
They actually feeded her the scram download, and so there haven't been any violations on it. But we just weren't able to contact her to come up to get that download until this was.
So, Judge, I contacted her Tuesday when I was in court and told her to go down there, and she went down there immediately. So, it's responsive to me. Obviously, I talked to her. She needs to be more responsive and to make sure that pretrial calls her. It's just like anything else.
I'm getting tired of the excuses. They tell you at the outset, it is your responsibility to stay in touch with pretrial, not their responsibility to have to beg and plead to get you to come in. I'm sick and tired of this, Miss Murphy. If we have one more issue, it's not going to go well. If you fail to ever stay in contact with them again, if there are any more violations, do you understand I'm sick and tired of it. I'm at the point where I'm ready to set your case for trial because you're way too much drama for me. How are we on discovery on this case? Because I'm ready to set this for trial. It's just way too much drama.
Getting on a 911 call, Your Honor.
Get on it, doggone it, because I'm ready to set this for trial. They need the evidence. So please,
Yes, Your Honor.
can you do me a favor and between the next setting, please have it ready?
And we're waiting on the blood as well, Your Honor.
Okay,
And we had to get the blood retested, Your Honor,
why?
because the agency, when it was originally submitted, the agency number was incorrect. So we had to reach out to the officer to get it resubmitted.
The lab rejected the submission because they put the wrong.
And Judge, the only thing they were missing was like 26 for the year, and they did the label, so I bet they were fixing.
Okay, all right, your normal reset.
Understood.
Okay,
Oh, no. All right.
Judge, are we amending the condition?
no, everything stays as is. Okay, all right, Kobe, take care, man. Hi, yes, ma'am.
I'm here, Mr. Watson. I did confirm that ISAP is not something that a misdemeanor court can impose. I was trying to see if,
We can't do it.
huh?
We can't do it.
No.
You look good. You look great. Right, that's great, Mr. Watson, fantastic. Banging. You know, really great. That's dress how you want to be addressed, man, really.
So I was trying to contemplate if there was something similar situated in like a probation that you want him to do, such as if it's the cognitive part, or are we thinking like we need for changing or?
I think that's probably a good idea, you know,
Was the domestic violence case law and it's bad.
I think it's great.
Putting the bit, I just don't think
We
that's,
know,
I don't think that's appropriate for the court to do in this situation, since the domestic violence charges are not out of this court, and he will surely be
let me see.
being imposed on something if he gets, say, a deferred or probation of felony
But
for that.
as judges, we are allowed to put and set whatever conditions we think
I'm
are
sure,
appropriate.
but he
And
is not pled up there, he's not pleading up there, you're basically punishing.
no. I'm saying if you want to do probation,
Uh-huh.
that I think that would be a really good condition to do. If you wanted to do.
He wants to do it, but Judge, this is something that if he chose to plead guilty in felony court, or do a deferred, or accept responsibility, saying, yes, I did this, and the only reason they've identified it on there is because of the charge. He doesn't, like, I understand what you are saying, but if that is appropriate, the felony court will give that to him in a deferred, or if he takes a probation up there, or if he gets TDC up there, he will sit in jail.
What's going on upstairs?
So we do have a TDC offer currently. Yeah, there's currently a 6-year TDC offer. I'm not too sure about
What is it?
6 years.
6 years?
Yes, I'm not too sure where they are with negotiations on the felony.
It's not always as well documented in the offer as what they're actually discussing in felony, so it's a little bit harder.
Okay.
What's the next setting up there? Do you know? Does it say? Because a lot of times on the resets, it'll say, or do you have any notes as to where they're headed?
July 16th is the next report date.
And
It's set. Or it's set for trial
oh, except for trial.
on the 17th.
Did you know that?
I was unaware that they had set it for trial. I knew that it was a possibility because if the offer was 6 years, he wasn't going to take it, but I was not aware that that actually was happening.
Yeah, it's set for jury trial. Pre-trial conference is set for the day before. So when we did a TRAS, the TRAS recommended in the alternative, it recommended the DV caseload with bits. Okay.
Well, it was in like the alternative or these are things that they have identified contextually, holistically, because they're considering this.
Count the slot, the two that targets in a position here.
So it wasn't really in the alternative to ISF. It was, hey, he has a DV charge upstairs.
And a prior DV charge here is with us as well. And then prior VPOs and quite a bit of, assaultive dangerous history. And so that's why we send them to see what would be the appropriate way so that it doesn't become an exercise in futility where we have just one rinky-dink thing. Okay. And then, 6 months or 8 months later, you're back with yet something else.
Yes, Judge. I understand that, but our stance is still the same.
And that's okay. But let's just set up a trial because I'm not going to. There are things that are appropriate and there are things that are not appropriate. And I don't think that just, I'd like to follow what it says because they know more. They know it's everything taken together.
Appropriate punishment to put on someone for a theft and a POM. He's only playing on the theft. He set the dummy for trial. He is shouting his innocence at everyone who will listen.
So let's do this. Let's set it for after the felony and let's see what happens.
Okay.
But I think the idea would be to address it so we just don't come back, and I don't know. All right, let's set it for the day after felony and let's see what happens. If they go to trial, we'll see. And then maybe you can work out a global resolution in the interim with the felony case, reach out to the felony court, see if there's something that globally you can work out. Just let's hope, Mr. Watson, let's hope that there's just no more violations in the interim, just that's all I'm asking right now, right? Just no more violation. That's it. Okay. All right. Okay. Don't worry about it. Just talk with Alyssa. Okay. Hi, Mr. Washington. Come on.
Good morning, Jerry.
Hi.
Judge, I think it's clear, right? In regard to Mr. Lockett, we're worked out clean, but we want to know the short. We said clean, we said in 17 days, we lost 2 jobs. One is a computer analyst, programmer, and the other he works in a warehouse, so it's really doing good. But he is going to pay this thing required 30 days county.
Okay.
And so we would like to let him work things out with this job, but we can take a police today.
Okay. Set a date to turn in.
Yes.
Yeah, I'm okay with that. Of course. Yeah, but it's, within 30 days. It can't be like.
That's what he asked.
Yes,
Yeah.
I'm okay with that.
Okay.
Yeah, absolutely. Okay. Are you ready? Come on up. Okay, Miss Mosley, come up. We told her not to use alcohol. We have multiple positive blows at 12 in the morning.
One positive blow enough to follow up. She did the retest.
Even one.
I understand, but our multiple incidents on different days, less than one.
Miss Mosley, I'm now going to put an ankle monitor on you. And let me tell you, this is my last ditch effort before putting you in jail. I have nothing left after this at my disposal. if you consume anything that has alcohol in it again, you will go to jail. Do you understand? Enjoy this big clunky device that you're going to get on your ankle. Super embarrassing, heavy. And if you test positive again, you will go to jail. Do you understand? Okay. All right. I'm going to amend the conditions, put a scram on her ankle. There's absolutely no tolerance. Next time she'll go into jail. All right.
Maybe.
Thanks.
Maybe.
Yes, ma'am.
Do we keep the same?
Once she gets scrammed today, then we'll take that device off. She will not have the device anymore.
No.
The portable.
Just the portable, wanted to set it down. Further, I believe they have.
Well, that's up to you. It's, you're at 113 days now. Is discovery complete?
Yes, Your Honor, and we do have an offer.
Okay. We'll give you, you still have maybe 2 resets left. So
Well, I just want to look forward to one on topic next week.
no. We'll just do a normal reset. She'll get the device today. Any further violations, we'll just have another bond violation here. All right. Thanks. Carson. Hey, bud. What's up?
Judge, first appearance on Mr. William, Ulliam.
Do you mind bringing your client here?
Sure. That way. Does it matter?
I need a date of why he mentioned this happening, so let's just put it
Good morning, Mr. Pulliam. So you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 4th, 2026, officer was dispatched to an assault call in reference to an assault from the previous day. Complainant was trying to purchase across while defendant was moving aggressively and sounding the horn in time to speak the line. Defendant entered the building aggressively and asked complainant why he had been sounding his horn. Complainant tried to show the line to defendant. While leaving, complainant was told the door open when defendant suddenly grabbed his bicep and forearm around complainant's head and neck area and forcibly applied pressure, placing the complainant into a side headlock. This was held until other drivers intervened. This caused the complainant physical pain and discomfort to his neck and head area. Complainant further stated he experienced soreness following the incident and was placed in fear due to the defendant's sudden and aggressive actions. Complainant stated that physical contact was offensive, unwanted, and occurred without his consent. Officer observed a video that was consistent with complainant's statements.
So this was at an apartment complex?
Over long haul trucking, this drop off center where they come in after the run, show the manifest, they're all queuing up. It's down near the Chicken Hill area. Judge, they haven't seen the video yet. I spoke to Karina. What I can tell you is that Mr. Pulliam's a 71-year-old man. There's a lot of lead up, probably 5 minutes of lead up to this. Our version of the story is the complete opposite of that. Mr. Pulliam pulls out, this guy pulls out, attempts to cut the line, and I have an aerial view of how this transpired. They had 5 different chutes that they pulled the trucks into, and this guy tried to pull up ahead of Mr. Pulliam. Mr. Pulliam goes in, as it was his time and right to do so. Gets out of his truck, not even talking to this guy, walks over to the building, goes inside where he shows him the manifest, not talking to this guy. He gets out, he's walking down the little handicap walkway. That's when the alleged complainant in this case approaches him, starts belling him up, pushing on him, yelling at him. It's a road rage thing.
Sure.
But the facts are, we have a complete opposite view of this, and we just need to view the footage to verify our story.
The thing is, though, Mr. Pulliam, is we put conditions on people for one reason and one reason only. Shh. That is to prevent any further incidents from occurring, right? Normally, what I would do is I would say, look, don't have any contact with the complaining witness in this case. Don't go back to the location and don't be in possession of any weapons. The idea is that I don't want you to accidentally run into him again. You guys exchange words and then you end up back in jail. You're the one that is on bond for this case. They can, and there are so many vindictive people in this life. This other person could very well call up the DA's office. Hey man, he's threatening me. And boom, another charge. You just never know who you're dealing with on their side. So the idea is to keep everyone as far away from each other as possible. My only problem is, how do we achieve this goal? Because you're a trucker, presumably, right?
Not anymore, we're both.
Oh, you both got fired.
He's not gonna have any problems with this guy.
Okay.
It was
For
a
the
random
time being-
encounter, and if I may, Judge, he's not a threat to anyone in society. He's gonna appear in court. You're not gonna have any issues. He's actually the father-in-law of one of my wife's coworkers, 71-year-old man, clean criminal history, law-abiding citizen that was involuntarily thrust into a tense situation. And, you know, I look forward to.
You know, the thing is that, you know, like I was telling you earlier, you never know who you're dealing with on the other side. You get a volatile person and they have a gun, you know, you just never know. Sometimes it's just not worth it. There's so much road rage around here that ends up in death. It's just freaking nuts. You know, you don't have to say anything. I mean, every day there's a road rage going on upstairs in trial because someone dies because there are way too many stupid people who have guns. Don't deserve, don't need, there's no need. There's just really, I don't know why. So, but anyways, just don't have contact with this person. Don't go back to the location for the time being. If you do get a job and something happens, then come back, we can talk. The only thing I'm asking you to do is just don't have any weapons, don't pick up any new cases, and don't have contact with this person. That's it. You got a great lawyer here. Listen to him. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. Carson will tell you if and when you have to come back to court in the future. Okay? Any questions?
No.
So for now, we're just going to be signing a reset. I'm going to have you take a seat. We'll get the bond conditions. Once you sign them, at that point, you'll be free to go. Okay? All right.
Thank you, Judge.
Thanks.
Have a good weekend.
Good to see you, man.
Judge states bond conditions?
Yeah, states. So no contact, no weapons, no going back.
If Mr. Fulham, right this way.
Yeah, we need you to sign a reset. Mr. Stradling.
Okay. Judge, I'm going to make contact with the on my case that I had earlier.
Okay.
She just wants to know the threat and harass.
Okay. Do you mind bringing your client up? So I will amend the bond conditions to do no threatening or harassing contact. You need to understand what is threatening or harassing is what the other person perceives. I don't give a rat's behind what you think. If you go like this, is that threatening or harassing? It is, and it can land you in jail. I don't know what kind of relationship you have with her. Obviously, there's a divorce going on. Like I was telling you earlier, there's a lot of vindictive people in this site who will use everything they can as leverage. So you need to be careful. I've seen many people, they say, oh, nothing. And then, yep, we have people calling over here to make all these claims. You know what I mean? Just be very careful. Okay. So we're going to have the, just once you sign the conditions at that point, you guys are free to go. Okay, great. So he'll sign, once he signs the amended order at that time, he's free to go.
Thank you, sir.
All right.
Is the location restrictions the thing?
What do you think? Karina, what do you think about the location restriction as far as this gentleman?
Let me see if the answer to she was texting me back. She does indicate that they share children, Judge, so my understanding is that he might go to pick up the child at the location. I was explaining to counsel that whatever, if we can include like family law case, so however they have child pickup,
Okay,
we can just
Right,
monitor
yeah.
whatever.
we'll just follow the family law orders if there are.
Yes,
Actually,
they're all-
she just answered, Judge. She would like a protective order where she can't come to the house. To stay in place.
Okay, so no going back to the location. You can have contact, just no threatening or harassing. Okay, it looks like there's really just be very careful, you know,
I agree, Judge. And is that the Moab condition or is it condition upon?
both.
Both.
Both. Yeah, no, it's on the order for protection. If you go back, it's in the order for protection that you're not allowed to go back. If you go back, you're in violation. They could file another
Okay.
case. So that's why
All
be
right.
very careful.
You know, we need to amend that.
You just come back, we'll talk,
Right.
right? Time tends to heal wounds, but for the moment, just
Okay.
be careful.
So that'll, you know.
It's over there. She. Yeah, hey, Veronica. So, you know, Aaron. No, I understand. I mean, if I run into the big guy, I have to. Oh, okay. I don't want to be out.
I don't want to say he's a, it's kind of a bookkeeper is normal.
Yes.
Yeah, let me just go out and it's great.
Yeah, for sure. Okay, are you, Mr. Lockett?
Yeah.
Sorry, let me just do this real quick. Mr. Lockett, you're charged with driving with while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 3 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
Yes, sir.
Do you know what happens if you ever pick up another DWI?
Yes, sir.
What?
I go to jail.
Wrong. Prison. Up to 10 years in prison, Mr. Lockett. And you don't have a very pretty record. Every time you get pulled over, the faintest smell of anything funky, what's going to happen? Well, very possible. I don't know, but for sure, they're going to look at your record. You smell like anything for the rest of your life. Even if you have a drip of alcohol, I wouldn't get into a car. It is a huge risk. Do you understand?
Yes, sir.
How do you plead to the DWI? Guilty or not guilty? I'm going to find you guilty, sentence you to the 30 days in jail. I'll give you credit for the 3 days that you've done. I'm going to suspend your license for 1 year. Is he enhanced?
Yes.
No. No, no, but I mean, what day did you want to turn yourself in?
July 13th.
Okay. You must turn yourself in July 13th. You were still on bond in this court while you're out. All the conditions continue to apply. You're still not to consume alcohol. You are still not to use illegal drugs. You will be randomly tested. If you violate these conditions, you are looking at up to a year in jail. I don't have to follow this agreement if you violate these conditions. Do you understand?
Yes, sir.
If you fail to turn yourself in, likewise, the full range of punishment will be available for me to sentence you. You understand?
Yes, sir.
So you must turn yourself in by 6 p.m. on July 13th. All right, good luck to you.
Thank you.
Thanks. No.
Judge, how are you?
Like,
We have a plea on Mr. Ian. So we're gonna plea on the reckless judge, they're gonna dismiss the.
so I have to change this because it says $2,000 and 180 days, but that's not the actual, it's 30 days and the $200 fine. So,
You want us just to mention it?
yeah, that's what I was gonna do, just to make it easier on everyone. You are Mr. Guillen Cardona.
Yes.
Mr. Guillen Cardona, you're charged with reckless driving. You were also charged with, is it unlawful carrying of a weapon? Right?
Yeah, this is the.
Yes, Your Honor, he's still here.
And the agreement is that they're going to dismiss the unlawful carrying of a weapon in exchange for your plea on the reckless driving. Is this how you understand the agreement?
Yes.
You were giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, this will go on your record and it will be there forever. Do you understand?
Yeah.
How do you plead to the offense of reckless driving? Guilty or not guilty?
Yes.
Guilty?
I am guilty.
Okay, that's what we want to know. As part of this agreement, you will lose the weapon. You will not get it back. It will be forfeited to the state. You guys are doing a sentence of 45 days, but I think the max is 30. So
Yeah, well.
I think
Now
we'll,
we know.
right, so, we'll do the,
Either way, yeah, 30%.
okay, I mean, regardless, it's the same outcome, but I think that legally, let me make sure, but I think that that's gotta be it. So we'll have to amend it, okay? All right, I'm going to send it to the agreement. You have sufficient credit for whatever the sentence is going to be. Understand, though, you now have a minimum sentence from now on. Do you understand? And I'll let them explain it to you. Good luck to you, sir. Thank you. Hi,
Good morning, Judge.
Good morning. Of course.
It's for case number 260.
Okay, give me 1 second. Let me get there. 260.
5078. And it's a brief,
Wait, on Zigrang?
yes.
Okay,
The client is traveling to Alabama this week with his dog. Leaving today, this afternoon, coming back Sunday. He has no travel restrictions, but in the event there's a raid anyway, would the court allow him to submit on Sunday?
so what'll happen is no, because that will defeat the whole purpose of random. So what happens if he's traveling, he's in the United States, right?
Alabama.
Okay, great. Alabama has a Quest diagnostic. He will have to go to a Quest diagnostic if he gets called within 4 hours and get a test done. That's the only way that we can really see if someone, so I'm okay with him traveling, but understand if he gets called, he has to go to a Quest diagnostic. Nowhere else. It's got to be a Quest so we know it's legitimate. It's not something where you can just go buy a result and just, just, she's really busy. If you want to write down the information and give it to Veronica, I'll amend the bond conditions to allow that to happen and we'll waive the signature. Okay? Of course. You got it.
Yes.
You're getting.
Carl.
Yes, Judge.
Hey,
Morning.
good morning.
Charles Miles. You wanted to be here for a BBR. I think it's just the allegation that he wasn't doing his emails. But in fact, he had. And he tried to simply go free out of it. The fact that you go through those, the signing sheets they have. Compliance, just, they don't have it on record. See about the miscommunication between three.
Mr. Miles, come up.
Serious.
Why has pretrial services been able to get a hold of you, Mr. Miles?
One time they did call me at this is not there. They, I answered and I faxed them over the sheet from, it was like February when they had called. And I told them that when I put the HCTXPT SIID to scan it from my job, because I have when I go to always use it from work, it never goes through. So the last time I sent it, I had to scan it to my work email and it forwarded to me from there. I don't know what's going on. Why is it not seeing me on the TV? But it
Veronica,
scans right into me every time.
this is Mr. Miles. How many times have you guys tried to reach out to him and have been unsuccessful? Please.
You change phone numbers?
We attempted to call on 611, no answer. We attempted to call on 69, no answer. We texted on 5. Last contact was on 5/7 when we called us and said that we had a vehicle problem.
Mr. Miles,
The phone number that we have is 409-719-030.
No, that's not number.
they have attempted to call you on at least 5 different occasions and they have been unsuccessful.
So, I can say that I work and take care of my job and my phone is constantly ringing. So,
What on earth do you think? I don't, why do you think we care to listen to excuses? You are on bond for a serious case. We gave you bond conditions and you have not fulfilled your end of the bargain.
You've been going, Judge. Order the A leave.
it's 6:30 in the morning, sunset. They don't get this crazy when we, go online. And then April, I didn't have to, I called the whole time. The machine at Friday. I'll be ready.
If I hear one more time that they have a problem getting a hold of you, I will put you in jail. You understand?
Yes.
This is unacceptable. You are to remain in contact with them, and they tell you that when you first sign your conditions. Not only does she tell you, but you have others tell you. So they tell you multiple times what the expectations are. I don't care that you're at work. I don't care that you're at home. I don't care that you're on the toilet. I don't give a rat's behind that you're on a freaking unicorn. You have one more issue. You will go to jail. Do you understand? Can you please make a notation that in the event that there's ever a communication that is a failure on his part to file another BVR, and then we'll bring him up here, please? Okay?
Thank you, Judge.
Thanks, Carl. Hey, ready? Hey,
Morning, how you doing?
good morning.
But I'm here on the Dick Ross, a gentleman that, he was arrested on probation, he's Sequent City, San City County, I'm sorry, San Diego County. And that's why he had, well, he wanted out a little further, and he's here. And or he's back. Make one.
That was July 9th. Did that work for you?
Did you test Mr. Peralta today?
Yes, I sent him to the office. I could see the result.
Where's your client now?
Yeah.
What's he on probation for?
I think it's in possession of controlled substance. Milestone. It's the only violation you have.
Yeah, I'm gonna let you fix it for on file when you're running and because I'm not charged.
Oh, he picked up a new case.
Yeah.
While I'm on for this case.
Well, I'm gonna go here. All right, fine. Let me double these again.
Did he pick up a new case?
I'm running his NCFC right now, Your Honor.
Okay, oh, I'm sorry, he was on probation for Another instance, until we violation for previous, sorry, I just read that.
So, make one story short, he's on probation at San Jacinto County, possession of controlled substance, he got 4 years deferred. He then has no other violation, they can show you the motion to do the case. This is the only other violation, blood came back, it was 0.08 case. There's some issues on the case, and if he didn't show up for it, or whatever he was supposed to do. It was good.
He's supposed to show up for a drug test.
Right.
Things today, because that's a negative.
He does a negative today. Mr. Peralta, come up. If you fail to test again, I will revoke your bond. You understand me?
No, you didn't go.
If they called you to go take a drug test on 5/27,
If he didn't show up, not custody.
when did you get out of custody?
I was under 17 to be 4.
That's not my fault. You're the one that's on bond for this case. You're supposed to show up. It's not my fault that you're on probation and in another case in another county for something else. You still have to show up.
You can't.
I get it. Listen, I'm not going to do anything today, but if you fail to show up again, I will revoke your bond. You don't get to pick up multiple case after case after case after case and expect good things to happen. It just doesn't work like that. When you pick up multiple cases, there's consequence to action. Do you understand? We hold people accountable for things that happen in life. You are old enough to understand that actions have consequences. If you are on bond for a second DWI second, and you're on felony probation for a PCS, if you put something into your body that you don't know what it is, it's probably not a good idea. You get my drift. Does he have a license to drive?
I do not have a license number, Your Honor, but I can look him up through NCIC.
What does he have any device now? I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, because you will have a blow schedule, if you fail to blow into the device when you are ordered, it will now be a second bond violation, and it's just not going to go well. Do you understand? It's a second DWI second. He doesn't have a license, so he's not allowed to drive, and he needs a portable device.
All that makes sense. The 0.08, Judge, I think is an issue. Furthermore, Judge, I understand what you're saying about a bond violation, but when he was in custody,
I'm not putting him in jail now, Frank.
I understand, but you're holding him accountable for not showing up, and it wasn't.
If I was holding him accountable, I would put him in jail.
Okay,
You know what I mean?
Yeah.
I understand.
But understand, you're walking out of here today, there's a problem. The only thing I'm asking you not to do is do not consume alcohol, do not consume illegal drugs, because it's a second, you're going to get a device that you will take with you everywhere you go to prove to us that you're not using alcohol. If you do not have a Texas driver license and liability insurance, then you're not allowed to drive. They're showing that you don't have a license to drive.
And I found his license, but it is not eligible.
It's not eligible. You're going to sign a promise with me today. This is an affidavit that you're going to swear to me that you're not going to drive. I don't care that you have to work. I don't care that you have to go take a child to the ER. I don't care that you need groceries. There's no justification that you can give to drive at all. Do you understand? Yes or no? I want you to understand that we take this extremely serious. That's why I do this, so that you understand it's not a joke. When I'm telling you don't drive, do not drive. I'm telling you, there's no more, other than consuming alcohol, there's no more way that you will make us more upset. I'm not asking much from you. If you want to drive, go do it the right way. Go get your license from DPS and get insurance, and I will happily let you drive. But if you get into an accident and you maim someone else and you don't have insurance, not only will you have messed up your car, but their car, who knows what kind of injury, and they're not going to get any money out of it. You know what I mean? It's just not fair. That's why we do what we do. If you do happen to get your license and insurance and you want to drive, come back to us and we can talk about approving you to do that. Don't just do it because you think you've got it. Don't. We need to make sure that everything is right, all the documents are in place, and then we can allow you to drive if you do, if you want to. But life tends to reward you when you do things the right way. And when you don't, there's just serious consequences. And I would have hoped by 1, 2, 3, 4, 5, 6, 7, and now number 8. Good luck.
The only thing I can turn is a little bit. So, he's, last time we were here, he told me that he put a machine in his car.
He doesn't have a
I'm just letting you know,
license.
so.
He doesn't. The reason we do that is so that you can't drive. So we know that you're not driving.
No, my point is, last time, interlock was ordered in his vehicle, and he put it in, so he drove here, and how do we get home?
That's not my
Is
problem.
that your problem? Okay.
You are not, you know that you don't have a license. You're on felony probation. Driving on a suspended license is a Class B misdemeanor, just like a DWI, facing up to 6 months in jail. Do not drive.
Okay, thank you.
You know, you have a lawyer. I'm trying to impart to you to give you the best chance so that you don't go back in. It's up to you from now on. Hi.
Yeah.
Walker, jail or bond?
I'm sorry.
Jail or bond?
No, Walker.
Oh, you a walk through. I thought you said you have Mr. Walker. Okay.
Oh, yeah, thank you.
Linton, come up.
Rivera?
Did you get the cause number for this? Obviously you did. Did you get it? Okay. Who'd you get?
Yeah, he's almost there, but you're not operating.
There's also a different motion to, take it raw and so I can get one, so I can be at that.
There's a motion what?
To withdraw on it as well.
Okay. You are Miss Linton.
Yes.
Miss Linton, you're charged with unlawful restraint. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Your Honor, I'm reading from the James on this one. On June 8th, 2026, also was dispatched to a possible terrorist threat call. Officer focused on complainant.
All right, go ahead and sign it.
Sorry, Your Honor.
That's okay.
Go ahead.
Officer spoke with the complainant and also on scene was a proximate witness. Complainant stated he was supposed to meet child mother, defendant 2.
Yeah. There was a couple of.
Sorry, I was making sure. Identifying argument correctly.
I mean.
So the complainant stated he was supposed to meet defendant at Kroger to drop off his daughter after his visitation. The defendant stated that the defendant never showed up, so he drove approximately 1 mile to defendant's residence to drop off the child off. Complainant stated when he pulled up to the residence, he parked on the opposite side and then instructed the child to go knock on the door, while the complainant and witness remained in the vehicle as an attempt to avoid confrontation. Complainant stated he observed his child go to the front door, received no response. Complainant stated the co-defendant then arrived on scene in his vehicle and blocked the roadway, preventing him from being able to leave. Co-defendant exited his vehicle and became aggressive with complainant and the witness. Co-defendant told the child the front door was unlocked to go inside. Co-defendant became verbally aggressive with complainant, telling him to step out of the car, and at one point made his hand into the form of a gun and placed it inside the complainant's front side window. Complainant said the altercation lasted approximately 10 to 15 minutes, at which point defendant arrived on scene and also used her vehicle to block the roadway, prevent complainant and witness from leaving the location. Complainant provided multiple photographs and video evidence to corroborate the statement.
So the alarm restraint is the fact that they were blocked with a car,
Yes, from leaving the driveway.
but was she in the car?
The defendant.
Yes, Miss Linton. Where's,
The defendant arrived on scene and also used her vehicle to block the road.
okay, so
So I believe those both defendants' vehicles were on.
have we,
But I mean, if the roadway was allegedly blocked by somebody other than my client, yet my client, if my client pulled it to the side, that he said it as blocking the road, I don't believe that's probably because he said that she already blocked the road.
Over 2 cars can walk the roadway.
right, I mean, I don't understand how they did it, but you're saying that you have 2 cars that blocked him from leaving?
Yes, so per the the complainant states that both defendants used their vehicles to block the roadway.
Does it say how? I mean, ultimately, that's a conclusory statement, right? That they just blocked the car. How? Who did what?
Taking a look at the DIM journal, I haven't had a
Sure.
chance to review the case yet. Additionally, Your Honor, complainant also attempted to drive up on the curb to get around the vehicles and around, and get out, but defendant placed her body in front of his vehicle, preventing him from being able to do so. I believe that the cars were parked. Doesn't give an exact location.
Was one in back? Was one on the right side? One in front? I mean, I guess you're saying she blocked him from
Yes.
in the front. Let's do this. It looks like we're gonna need a bit more time. Let me just finish with them so I can give you the proper time that you need just to see if there is or is not probable cause. Ma'am, just take a seat for me. I want to take more time just to make sure that there is probable cause. I don't want to just find it for the sake of finding it. We take it seriously. We go and dive into every case, but let me get them out because there's probably a little bit short and we're gonna have to see if there's a diagram or something, okay? Do you mind just taking a seat real quick? Give me 2 minutes and maybe we can. Yeah. Well, he's getting on the case, right?
Yeah, I'm not sure.
Yes.
Okay, great. So it looks like someone else, is there someone else on the case?
That's what it is.
Okay,
We both listening.
I think he's,
Okay.
okay, are you ready?
I am ready, Judge.
Come on, Mr. Francis.
How are you?
Hey, what's up? Sorry to keep you waiting.
No worries. Kevon Rogers.
Roger.
Here, he's in the box. We're addressing the BDR this morning. So on Monday, this past Monday, there was a BDR issued against him saying that he tested positive for marijuana. However, Mr. Rogers was given bond conditions on 5/15. He reported for testing as instructed on 5/19 and tested positive. We would expect that. He was
That's not the problem right now. That's not the problem right now. Come up, Mr. Rogers.
He was then again requested to come on 6/1 and he tested positive as well. That's 14 days after.
That's not the problem.
Okay.
The problem is that we gave him a curfew and he's out at 1 a.m.
And I understand that. And I spoke with Mr. Rogers about that. He's telling me that he lost his charger. He fell out of his backpack. He's looking for his charger. His ankle monitor is beeping and he looks in his backpack, can't find his charger. And he goes back to the last known place that he was, which was 2 blocks from his house. He's running back
At 1 a.m?
At 1 a.m.
Right. No, it's your third bond violation, man.
Judge, I've asked pretrial services to find out, to confirm whether his device was beeping.
I don't care that it's beeping. I don't care. I care that you're out in the middle of the night and I told you not to go out in the middle of the night. It's your third bond violation. You're going to jail. I'm revoking your bond. No, it's your third time and you're out at 1 a.m. Wait until the morning to go look. You know you're on bond. You know you have conditions. It's your third bond violation.
If his ankle monitor would have died, he would have been in bond violation anyway, Judge.
I'm sorry that you lost it. Take better care of it next time. But really, it's the third bond violation. You're out at 1 a.m. Sorry, you're going in. Goes with you. Thanks, Mr. Fritz. Okay, are you ready?
Yes. So I want Mr. Watson.
5,000. Rogers, yeah, 19. Okay, I'm sorry.
So, no, you're fine. I think Mr. Watson, he was okay, accepting the conditions that expressed to me. So we have a probation that we have signed and included the bit and the domestic violence caseload, if you would accept that.
I mean, are you sure?
I asked him, I asked him when I talked to him.
Come up, Mr. Rogers. I'm sorry, Mr. Watson. Sorry, I still got Rogers on the brain. Oh, do you have? Go, Mr. Yeah, please. Talk to me. What do you want?
I'm just, ready to get out, I'm ready to finish, and, I was just want to get it behind me. This happened 2 years ago, and whatever I gotta do to get it behind me and better my life. So, I mean, I'm not.
That's the objective, Mr. Watson. You have quite a rich, lengthy history. You got to realize every time the laws get involved with you, no matter who it is, no matter what's going on, when they start to learn who you are, the buck is always going to be under regardless because of who you are, because of your history. Your history says a lot. And even if nothing is your fault, right? Your history is going to dictate how a lot happens when the laws are involved. It's the reality. And I've told you, perception is reality. It is. If
what's on back in the head, it doesn't make it look like the person I really know.
Everything that we do here, as miserable as it has been these last couple months, it's so that you don't come back. You think before acting, because sometimes you got but just a nanosecond to think, if I do this, what the hell's going to happen? If I say this, really, it's not. And now with your history, you may be looking at, is he a habitual? You could be looking at a lot of time. I mean, you see what the offer is upstairs. When it racks up, it doesn't get better. It gets worse. And at some point, DAs are like, well, you know what? This guy just doesn't get it. It's just more and more dangerous. It's time to throw his ass in prison for a long time. Because that's when it continues to happen. That's the mentality of everyone.
So can I say something? I mean, I understand I got a very lengthy criminal history, but a lot of this stuff happened when I was fresh out of high school. I was young. I'm about to turn 30 years old the next month.
The law never forgets.
No, I understand that.
It's a jealous mistress that's on your back, pecking away for when you're 70 years old. If you pick up a case, if you're 70 years old on a walker. All right, Mr. Watson, so 3 cases will be dismissed. I'm sorry, 2 cases will be dismissed. He's pleading on the theft. Is there any restitution that's no? All right.
That's your, and, he was detained on the scene for, the deputy's plea.
All right. So you're charged with theft. You're facing up to 6 months in jail and or $2,000 fine. The agreement that you have worked out is 180 days in jail to be probated for 1 year. So we've already done the TRAS. I don't think that there's any need to do it again. The only conditions that you have are an anti-theft class, the batter's intervention prevention class, and just stay out of trouble. Don't use alcohol. Don't use illegal drugs. You're still on bond for the case upstairs. You know that everybody's still watching out. We are done today, but understand your life is not yours until everything is done and over. At that point, your life becomes yours. And I'm hoping that, great decisions are made. There's no mistakes in this life. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it's over. Is this what you want to do? How do you plead to the offense of theft? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 180 days. I'm going to probate it for 1 year. Where is this theft from?
I believe it's an academy you're on.
Okay, so no going to academy while you're on probation. In this case, you must do just the anti-theft class, the BIP class, and that's it. Just stay out of trouble. Do not pick up any new cases. Don't test positive while you're on bond. Are you working at this time? What are you doing?
I work for a speed license and delivery company, package
Are
delivery.
you working full time?
Yes, sir.
Great. You just work full time. That's all you got to do, and just stay out of this. All right, bud, waive his fees. I'm waiving all your fines and fees. You're not going to have to pay anything. I don't care about the money. All I care about is you learning from this, getting these 2 classes done. If you ever have a problem, call Alyssa, come back. We can work through anything. The worst thing you can do is pick up a new case, take off, because that's just an instant warrant. Do you understand? I swear, if you ever have an issue, come back. You need a job, you need a place to stay, we will help you out. It's not hard. But if you don't tell us anything, then we just don't know and we can't help you. All right? Good luck, Mr. Watson. Thanks, Alyssa.
William?
Honor, may I approach?
I know you're fine. Great job. Hey, no, really great job. I get it. It's just,
Yeah.
right. And I hope it's ready.
Your Honor, may I approach?
Yeah, I'll hit you up next. I'm sorry.
Okay.
I know you're there.
No problem.
Evans, I'll hit you up next. Sebastian.
Okay.
I have Jones, on the bond market. We get several Jones a week.
Jones. Okay.
So he bonded out, I guess, yesterday. They can give a PR bond until yesterday, and so finally got out. His bond paperwork on the case he just bonded out. So with that, the court date of the 18th. The ones before had his court date as 12. So what I'm asking you, he's been competent as well, Judge. I have some.
How did he get another PR bond? I mean, he's on bond for 2 other cases, and
I'm not sure, Judge. He was in until I think they got
you know what happened was you guys dismissed an assault in April.
Oh, okay.
So on the evading, and are they all three set for, well, the evading and theft, they're on for today.
And then the one that you bonded out of, that was keeping him in. That one, you got a PR bond. It was yesterday, the day before, bonded out yesterday. And that one had a date of the 18th. So what I'm asking for, Judge, is to set up for bond forfeiture on the 18th. And I can.
No, he's supposed to be here on the other two cases. I mean,
But Judge, he's in contact. He has never been restored. I would ask that.
do you have a way to get in contact?
I have contact numbers with family members. I'm just asking that if I can find them. If on the 18th, it's, moot point, then it's, that it is where it is, but, that's that, just in this circumstance, that we at least try to get out here.
All right, fine. SFBF, all of them, please, for the 18th. Yeah, all right,
Yeah, but the,
okay. All right, Sebastian. No. You can approach, but let me, Mr. Evans, talk to me.
Yes, good morning, Your Honor. I'm approaching on Carol. I approached on Tuesday, but it seems as though I got assigned to one of his cases, but we already discussed it. It was filed last week. It's the evading charge that was recently filed today.
Carol is the last.
Cash.
Where's Mr. Carol? Is it Mr. or Mrs.?
Mr. He's in custody.
Oh, he's
He
in
has a
custody.
pending felony. Yeah. 2 misdemeanors and a felony.
Oh, he picked up an aggravated robbery. No, wait. Okay, you just want me to reset it?
Yeah, that's all.
Yeah, so we have it the day after the felonies. You want to do that too?
Yes.
Okay.
Yes, sir.
All right, so we'll put them both for 7-8. Looks like one's already on 7-8.
Okay.
So let me ask you, Mr. Evans, we have an evading on 6-4, a theft on 6-5, and then an aggravated robbery on 6-5. Did he get out on our evading and then he picked up the aggravated robbery and theft the next day? Or were they late filings?
I think they were late filings.
It looks like, the offense date for our evading is after the aggravated robbery and the new theft. So I believe in Meg's been late filings.
Got it. Okay, so I'm not going to touch the bond then. I'll just gonna leave it as is. Okay, all right, we got you, buddy. Thanks for being patient.
All right, thank you.
Okay. Joseph, Ms. Hudson, you're next. Okay, hey, hi, Joseph.
Julio Lopez.
Okay, what's the word?
So he's here today, came from Mexico.
Oh, great, right. This is the guy that went on a trip to, hey, don't talk.
It wasn't even pleasure. That in the family.
Oh, right. Okay. Lopez, come up. Are we in the Center for TRAS today?
No, we've got an executed PTI contract, we've got a DA, I just need a little bit of time to get his device.
Yeah, we'll give you a week or two. Right. You're on bond for a criminal case. You cannot just up and go because you have bond conditions. If they call you to test and you fail the test, a bond violation gets submitted. I may revoke the bond. And let me tell you, if you were in another country and I revoke your bond and they put you in jail, it is a huge mess and you will be in custody for a long time. Do you understand? You have a lawyer. When you do anything, you need to reach out to your lawyer to apprise them of everything before you do anything. Do you understand? Okay. All right. So we'll give you a week to 2 weeks at the next setting. If everything's done, then he doesn't need to be here. But if it's not done, your case is 200 days. It's old. We're going to give you about a week to 2 weeks to get the interlock done. If you don't have it, you're going to have to be here at the next setting, and then I'm going to roll it day for day until it gets done. Okay? All right. Thanks, guys. Ms. Hudson.
Good morning, Your Honor.
Hey, will you do me a favor? From now on, when you come online, will you chat me who you have? Because it makes it a lot faster and it's really hard to hear. Okay, who you got?
It's an off docket matter. The case number is 260-8380.
260.
8380.
Is it
Quintano?
Guitano? Yes.
Yes, sir. So currently he has a curfew, from 9 to 6. However, a part of his bond conditions were to be enrolled in school or to get a full-time job. He has graduated, so he's been looking for a job. He has found one, and they made an offer to him, and I have a copy of the email, of the actual offer. But it's solar energy, so it requires him to travel. And so I was trying to get permission for him to be able to go to that interview or
I'm okay, Miss Hudson, but he's on bond. So if he has conditions that order him to undergo testing, if he gets called to test,
okay, will he be able to test in whatever city he's in at the time?
yeah, so it looks like
Okay.
So if he's got to go take a drug test, if they call him to go take a drug and alcohol test, he's got to go to a Quest diagnostic wherever he is within 4 hours.
Okay. Okay.
I'll write the case number for you so you have it. On Quintano? You got it? Okay, so just wave the signature as well. Okay, all right, we got you, Miss Hudson.
Okay, and one more thing, Your Honor. He did inform me that he has a mandatory drug test on the 17th, which I believe is also his next court date. But that's
No,
the
his
same
court date's on the 16th.
on the 16th. Okay, so perfect.
Yeah.
So okay, that works out. Thank you.
Yes, ma'am.
Bye-bye.
Okay, Mr. Caraba.
Yes, sir, Judge. I appreciate your time. I'm here on a Sharon Welshamer.
What's the last name?
Welshamer.
Welshamer.
W-E-L. Yeah. Judge, it was just a return on a pretrial diversion. It was my understanding the state was going to dismiss 2 cases that were done under the pretrial diversion. She just texted me and said she got her paperwork. I was just checking with the court and see if y'all needed me there. I had to go to Washington County, and I'm traveling back.
Let me check if it's ready to be is it ready to be dismissed or no? Has she completed?
I think it is.
Caraba?
Yes, sir. My understanding she has.
Okay, let me verify it here. Just bear with me
Yes,
a second.
sir. Yes, sir.
Do we have a dismissal on Welshamer? But it's page 24. You see.
Judge, I gave her a copy and she left.
Oh, so they did dismiss. Okay, no, it's been dismissed. We gave her a copy and she left.
Judge, I just want to check. It was 2 cases, correct? It wasn't just the one. It was actually 2 cases for this particular.
Oh, I don't know.
I believe we filed dismissals on both.
Okay.
Let me check for you. Give me a second.
Yes, sir.
Our end, I believe Serena filed this.
Yeah, they're all both dismissed, Mr. Caraba. You're good.
Thank you, sir. I appreciate it, Judge. May I be excused, sir?
You got it. Thanks.
Thanks, Judge. Appreciate it, sir.
The lawyer that we were. Are you ready? I have to draw a Venn diagram just to figure this damn thing out, man. I mean, really. So.
I haven't had too much of a chance.
I know. Take 5 minutes, take a look.
This is the thing I think, Judge. They said that she locked the car when the road dog already locked. He tries to back up his head and she gets in front of the car because he leaves. So, and nowhere do we hear threats, coercion, intimidation, or violence that restrain him. So even if we take a case like that, she blocked the car from driving away from the street, there's no restraint on him in person. So if he
does the statute say that?
Well, the statute says that he must restrain him, right? So then.
Well, so I mean, why are you putting in more than it needs to be?
You know what I'm saying? That if she didn't physically restrain him through threat, word, and violence.
It doesn't have to be physical, though, does it?
Well, I'm not sure any way that could keep somebody from going if it's not threats of coordination.
Let me read it, just because, right? So a person commits an offense for unlawful restraint, penal 20.02. A person commits an offense if he intentionally or knowingly restrains another person It's an affirmative defense to prosecution under the section that, number one, the child restrained was a child younger than 14. The actor was a relative of the child, and the actor's sole intent was to assume lawful control of the child. No. It's a class A misdemeanor, except that state jail if it's a child younger than 14, third degree if substantial risk of bodily injury. So basically, a person commits an offense if he intentionally or knowingly restrains another person.
Right, so if okay, let's look at that. So I say you're not taking my car. If you get out of my car and you walk away, I'm not restrained. So it's the person that must be restrained, not the law. So you take on face value that she got.
Well, but he's in the car, man. I mean,
but it's not. He's not physically held at that position. If you take that, but it's honestly.
he has the right, if he's in a car, he has the right to leave with his car. He doesn't have to get out and walk. Is that out?
No, I think, well, Susan, one, and the second one, I don't think he was actually restrained because he could have hurt away.
So, okay, look, under the Texas Penal Code, section 20.01, restrain means to restrict a person's movement without consent, interfering substantially with their liberty by either moving the person from one place to another or confining the person. So by them remaining in front of the car, have they confined him to that space?
No, because that means that anybody who does so, that they're in the parking lot, and I haven't even fact about providing.
Yes, that's right.
Right, but I don't believe that's what the legislation. It's, I think the legislation is that I'm thinking that forced to keep you leave. I did something that made you feel like you were not free to leave, right?
Why do you have to put force?
Because, and I'm looking for a tip I just saw before, but there's people that said that, showed up, during the course of enough for this case. For this case, it's a five. And I'm trying to find where I saw that.
I mean, we've got time. If you wanted to just stand down and just take your time while you look. Restraint is considered without consent if it's accomplished by force, intimidation, or deception. I don't know. What the hell does that mean?
Well, that's what, right. So it's right, if you're looking at, Reba, and that's what it was looking at. So force, intimidation, or deception, that's actually their job.
Or by any means, including acquiescence of the victim, if the victim is.
Yeah. Your Honor.
Did we find PC on the code offense?
Your Honor, the complainant is used in tears.
But he said that before my client, when my client arrived after the fact. She was in fear of the first defendant made a pistol and put it into his car, I guess, that's being scared.
And Your Honor, the co-defendant is still in warrant trial.
So read it from the top again, if you don't mind, will you?
Yes, Your Honor. Officer was dispatched to a possible terroristic threat call upon arrival. Complainant, who was on scene with his girlfriends, were supposed to meet his child's mother, defendant, at a broker, so she did not show up. They then went to defendant's residence. Complainant stated he pulled up to the residence and parked on the opposite side of the residence and instructed the child to go knock. There was no response when the child knocked. Defendant one then arrived on scene and blocked the roadway with the vehicle.
So defendant one is the other person,
Yes.
the co-defendant, okay?
And this prevented the complainant from being able to leave. Co-defendant exited the vehicle and became aggressive with the complainant and the witness and told the child to go inside. Co-defendant was verbally aggressive with the complainant, telling him to step out of the car and at one point made his hand into the form of a gun and put it inside the complainant's driver's side window. This lasted for about 10 to 15 minutes, at which point defendant arrived and also used her vehicle to block the driveway. Complainant.
Well, okay, hold on. That's her.
That's correct. That's already, the road was already blocked. I can't kill it. That person already dead.
Block the road, but there's more, Your Honor.
No. But what you just said was that she gets there, right?
Yes,
And when she gets there, she blocks him in as well?
yes, so it's.
How?
It's not say specifically how she blocked the roadway, but it states that complainant was trying to leave and could not leave, and more specifically, complainant or defendant. When complainant attempted to drive up on the curb to get around both vehicles, because both vehicles were blocking the roadway.
That's when she steps in front.
Yes, so, and complainant said he was unable to put the car in reverse in attempt to
Yeah,
leave.
I think that there's enough. No. I mean, he's trying to leave. He's even gets so much as gets on the curb to leave. And then she puts herself in a position to restrict him from leaving.
If he's already blocked, I don't see how she.
Well, he's trying, yeah, right. He's blocked from behind. So he's getting up on the curb so he can try to take off in another way. And then she gets in front. So he can't leave. You know what I mean?
Those are the problem we have to see, because I see, yes. But, so I don't say very low far here.
If you have any other evidence that shows that that's not true, come back and we'll hear it anytime.
Understood.
I'm always willing to rehear probable cause. I don't care just how old it is, but come up, it's Miss Linton, right? Miss Linton, I'm going to find that there is probable cause to go forward with your case. As stated earlier, you're charged with unlawful restraint. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. I understand that you have a child. I just don't care though. You are not allowed to have contact with this person whatsoever. If this person initiates contact with you and you do have contact with them, it is still a violation. I don't care who initiates the contact. When I mean no contact, I mean no phone calls, text messages, social media, email, use of third parties. If you do, then I will revoke your bond and put you in jail. If there's some kind of custody order or if there's some kind of family law case where something is different, then we can talk. But until this point, do not have contact with this person. Do you understand? Is there a protective order that can be issued?
There's not one yet. I can talk to Joanna to get in file one.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him and he'll tell you if and when you have to come back to court. As I've been preaching all morning, there's a lot of vindictive people in this life. You never know who is on the other side of who or what you're dealing with. You are the one that is on bond in this case. Records are always kept in every course of everything. Phone calls, text messages. If they show me that you're attempting anything, I will put you in jail. Do you understand? The reason we say all this is so that there's no incidental, because that can also land you in custody. Just don't pick up any new cases, stay in contact with your lawyer and all will be well. For now, I'm going to have you sign a reset. We'll have you take a seat in the jury box. Once we get the bond conditions, you sign them. At that point, you'll be free to go, man. Okay? All right.
Thank you.
Please. Thank you. Oh. Did she not pay a bond already?
Okay, with the locker.
He has $100 GOV.
I thought she was on bond. Does she have any prior criminal history?
I can write it right now. You're on that.
And what's your position to a PR bond?
Thank you. We would not be able to draw on.
Okay. No other criminal history though?
Or I just pulled it up right now.
Your mom is Miss Jewett? Your mom is Miss Jewett? Your aunt?
No problem.
I like her a lot.
No problem.
Okay, where'd she go? Come up, ma'am. I'm going to grant you a PR bond today, Ms. Linton, but I want you to understand, I'm going to grant you a PR bond today, but I want you to understand, this is not a revolving door. Just don't pick up any new cases. Be nice. It's not hard. And, all right? Okay. Thanks, guys. Yes, sir. Oh, yes, got it. Right. Okay.
Thank you.
Yes, ma'am. Thank you. Edge, did we miss anyone? Is there anyone out there that came late or?
Oh, yes, Judge, top of 5.
Celestino, come up. What time did Mr. Celestino get here?
Judge, he was here. He just got slipped over.
I remember Mr. Celestino. That's not a good thing when judges remember you. I want to say that we had a lot of problems with Mr. Celestino. And he had a DWI dismissed about 2.5 months ago, and now we're back on another one.
Yes, Your Honor, he had a couple bond violations.
Mrs. Celestino, you're charged with another DWI. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 6, 2026, officer received a call in reference to a reckless driver, which is reported that defendant hit a barrier and described defendants, provided a description of the defendant.
He hit a barrier?
Yes, Your Honor.
Okay.
Officer located the vehicle that was stationary on the left-hand shoulder and observed defendant to match the description provided by the witness. Defendant was, sorry, Your Honor. There was a crushed traffic from near the vehicle as well, and this area was under construction and closed off. Defendant advised the vehicle came from behind him, traveling at a high rate of speed, causing defendant to hit the orange traffic drum. Defendant stated he was coming from a gas station and had 2 beers at a family gathering around 11 p.m. When he was leaving the family gathering, he started to feel the drinks, so he stayed with his friend and left when he felt better. Officer observed defendant to have a mild odor of alcoholic beverage from his person, bloodshot watery eyes, and inconsistent statements. Standard field sobriety tests were conducted, 6 out of 6 HGN, and since they were on a major highway with an incline, the one-night stand and walking turn were not performed. Defendant refused to provide a blood sample, and the blood warrant was executed.
Does he have a license to drive?
I'm running his license right now, Your Honor. Your license is eligible.
Mr. Celestino, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you to get a SCRAM device on your ankle so I know that you're not consuming alcohol. If you do, I will revoke your bond and put you in jail. You and I had a lot of history with the DWI that was recently dismissed. It was literal one violation after the other. I'm not going to play this game with you. Do you understand me? When I mean no alcohol from any source. I don't give a rat's behind what the excuse is. Cakes, candies, foods, gums, tequila lollipops, hair dye. I don't care. No alcohol and no illegal drugs, including marijuana. You will be tested 40 days from today. If you test positive for illegal substances, then likewise, I will revoke your bond, put you in jail. This is not a revolving door. There will not be PR bond after PR bond. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If you do not have car insurance in your name, then likewise, you are not allowed to drive. We are going to reset your case to give you time to hire a lawyer. Do you mind doing the guardian interlock paperwork? You're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Do you understand? We will waive the fees. You will not be responsible for any of these fees, but I'm telling you now, if you consume anything, you're not supposed to. Do you understand? We will have you sign a reset. I'm going to have you get with Veronica for your bond conditions, and then we'll see you soon, sir. Please. Hey. Hi, good morning.
Amy Jones.
What's the last name?
Jones.
Jones. Oh,
She's not here, Judge. That's my fault. I saw your email late. You said on Wednesday, I saw it late yesterday. And trying to contact her last night. Wasn't able to get in contact with her. Seeing if we can just get ready until Monday. And I know it says that she picked up the student felonies, but they're both dated September 10th, 2025.
In our office yesterday.
Okay, so that's probably.
oh, she's in custody now?
Yes,
Oh,
she showed up to our office yesterday to report, and she's taking another two reports.
Man, I wonder if she was upset.
Um,
Do they so that she was just,
we had the report of what happened.
Was it-
She was thrown.
oh, well, yeah, she gets, yeah. Okay, I guess let's have a hearing on, because I don't know anything about the two new cases, and I know that you're saying that before, I don't know, let's see.
This is what's coming complaint from us.
Yeah, okay, wow. Okay, I guess let's put it on for Monday and we'll go from there. Yeah, oh, for sure. You guys do a great job, thanks, really. No problem. Hey, so on the reckless driving, I can only do 30 days. Are you? It's that hybrid thing where it's only 30 days and a $200 fine. So are you okay if and defense has already said okay as well. So, okay.
The last one is
Hey, what's up? Happy Friday.
Happy Friday. Thanks.
What's up?
I have two on the docket.
Okay.
First is Mr. Salamani.
Okay. Okay.
My understanding, we did go yesterday, Your Honor. They did complete the
Wonderful.
interview. I don't have the official results yet, but I did call over to the analyst and confirm that he did go.
Wonderful.
Yes. So at this point, Your Honor, I think the best we can do is wait for the result of determine his competency.
Sure. Yeah, I mean, it should be a week.
Yes.
So I guess you confirmed that he went?
Correct. With the Jasmine at the Howard Center.
Got it. Okay, I trust you, Alan. So where do we go from here, though? You know, he's PTI eligible.
Yes.
Alan has asked for the documents several times and he's just not gotten it to you.
Yes, and the MAC office said they'll help with talking to him again about trying to put together the mitigation packet. Spoke with the state. If he comes back with a competency issue, he may be eligible for a mental health PCI, which we're trying to work out as well. Trying every angle I can.
I get it. I'm with you. Just don't worry about it. I'm always with you. So let's put it a week. Let's see. Hopefully we can get it within a week and we'll go from there.
See, as today is Friday, would it be okay if you said it from Tuesday after?
Yes.
Thank you, Your Honor. And one other one, Your Honor, Mr. Javion Godfrey, he's asking if you would entertain a time, sir.
Oh, yeah.
Yes, I mean, I think that, well, let me see, how much credit does Mr. Godfrey have? I know it's gotta be substantial. Yeah, right. I guess the one that has the most.
So, the rating has 244.
I mean, why don't we just do a year? He's got enough credit for it all.
Yes.
Yeah, I'm okay with that.
I would, if possibly, I'd like to do it on all of one of the cases.
What?
Because he's got the felony. That's pending. So if by some miracle he's able to maybe plead on a misdemeanor for this felony, I doubt it.
Oh, I see.
The issue is bond is so high. He cannot, he's not just the bond out, so you can reduce the bond. And
It's 244.
What's going on upstairs?
my understanding is that Attorney Booker's got the offer down to about 9 years. They're trying to
9
see-
years.
Yes, Your Honor. I'm trying to see if perhaps he could get some type of probation. I don't think he can divide that. I don't think he can.
How old is he? Let's see.
But they're trying. Most recent situation.
He was born in 2007, so that's what, 20?
19.
Why can't he do Wyman?
I mean, the state hasn't said he can divide it.
Oh, you mean because of, can we talk, Mr. Godfrey?
I was asking her which one it was.
Yeah, Godfrey.
Okay, got it.
We've, as you can see, have a lot of history with Mr. Godfrey. 1, 2, 3, 4, 5, 6. He's been consistently asking for a bond reduction, and I've said no just because of all the baloney, you know. So he's asking time served now. I'm certainly okay with it. He's essentially maxed out for all intents and purposes, right? We
Yes.
could do a year in jail. He's got sufficient credit. But what Alan is saying is that he wants to leave one open so that in the off chance if they let him plead on a misdemeanor in exchange of, I guess, a global something upstairs.
Okay.
What do you think?
Do that, Judge?
The problem is that if he goes out, we have another case open and then he just has another violation.
Can he make fun on the ag law? Because wouldn't he still be held on the ag law?
Yeah, but I think that Alan is saying he's all our cases are, it's too much, but alone that is more manageable.
So.
I don't know. What do you think?
I would have to ask felony judge in regard to, because normally they want to go with plea or if they want to, which one are they okay with us dismissing, or putting, obviously, because we have the ag law, so I'm sure they'll be okay with the UC.
Oh, right. Do you want to, I guess you want some of them obviously dismissed, right?
Correct.
Could we do this? Could we reset it for Tuesday?
Yeah.
But in the interim, could we lower his bond, Your Honor? All right, yes, sir.
It's just too much. If you want to be done with it once and for all, I'm happy to do it.
Yes.
Sure. And I'm willing now, whatever you want, I'm okay. It just doesn't matter, but,
Yes, make it nice.
Email felony judge to see if we can resolve the misdemeanor and to link their will and see how they feel about that.
and then if,
Because I know if it's an ag law, I think they're gonna reduce it to a misdemeanor, they might do a robbery, but I don't.
I mean, typically, isn't that what's normally is, I don't know. And then how bad of a robbery are we talking to? Was there any,
There you go.
did someone get shot?
No.
That's good.
There's a gunpoint, family law.
Oh.
That's right. With the Family Dollar, really.
Scheme out, guys.
We had a Family Dollar the other day where it was like $600. I'm like, what?
The last one?
No, the theft.
Oh.
And the theft, the amount was around $600, and I'm like, Family Dollar.
Yeah. Wow.
let's set it for Monday or Tuesday, whatever you want, and let's just be once and for all, and then he can just worry about,
I would say.
wow.
She said that she couldn't open the savings like $5.
And then take action on $2,000. So you try to live, was cash and tracker.
If they get it back, you know,
I would think that they did.
there's a tracker. I mean, that's how they.
Yeah, I think it'll depend on when they caught him.
Because they had.
If they caught him with the money, then they probably got it back. If they didn't catch him with the money.
You know, and I guess put them on notice that we're about to resolve these cases so they know. I don't know what kind of conditions they have up there in the event that they, so, yeah, I'm down. Let's do it.
Thank
It's
you.
time. It's time.
I'll do that.
Thank you.
Yeah, okay, thanks, Alan.
Yes.
Hello? Hey, what's up? I saw your husband yesterday.
No.
Yeah, yeah. Yeah, he's a good guy. He's so good. Yeah.
Yeah, that's fine.
Twice a month. Still better than additional. Not issue, but you go to weekend, that Tuesday, come in. Okay, yes, it's here now. Yes. Israel cable.
Texas is the same one.
You remember what that? Always not. You do that? Yeah, it's not. I'll do that. Yes, I would also on the next weekend. I was not seeing the phone. Okay, we follow up and make sure we set it. Okay, that's fine. Sure. Thank you very much.
We'll be able to get it scheduled. His
He did. Oh, he did.
Oh, he did.
We're just waiting on the results. We're setting, to see what the results say. Because if it's comes back to people, it's not.
Okay, I.
That's all.
Yeah, I highly recommend you take your to that.
Oh, I should. You guys can take that to the board.
We're like in right now, I'm doing nothing.
So, Ronnie, here you are. We're free to go. Have a good day.
God, great.
This is one that we did, if you don't get a child, we don't do any sort of. We do that, you, we gotta do. With the class service, what we don't do that. Yes. Okay, so You had asked second for him to still getting.
Yes, it was chicken.
I guess the right is here. Not sure. Group something. And client, you're saying. You said for maybe see what directions.
Yes.
Oh, but he's. It's
He's been in.
That's good. It's
85 day. At least.
I just want to see his life stuff, like.
Oh, yeah, oh, it's the second, yeah, okay. So yeah, you'll buy it and maybe. One year.
During the consultations and then, all the results that
You might want to come out.
But only worst case scenario, like, you know, still,
Oh, yeah, that's good. That's the only thing to see in this.
yeah, it's on Friday.
Tell me, what are you trying to do?
Yeah. And wasn't that.
It's great.
I'm just only sure that I'm not changing the conditions in our.
Let's see how much.
I'll do it, yeah, but I think that just extend it.
So, you know, appreciate service officers, sometimes we have to live and realize in our office, we have.
Yeah.
So, okay, that they do that.
I'm not sure, that's a DPS.
He's gonna do it.
I feel like that.
It is really well for she's set up the cancer. You get don't have costs, but he has a prior distance. He's repeating the you have the okay. I found
Good.
Just for it. They just thought they're bad.
See, I'm going to add the sometimes.
Okay.
Swirling,
what's up?
How much, going to any poker here?
I saw yesterday.
What's up?
I watched it yesterday. It was great, but no, man, it's, you know how expensive it is? It's ridiculous. I mean, it's,
I've got a good price.
what's a good price?
I got hospitality, 500 pieces.
Oh, yeah, that's, okay, I think that's,
And then my cousin actually won the lottery. Or not the lottery.
yeah, but,
And you got big value, like section 3.
Wow.
Cowboys gates, we get 6 of them. He's family flies, he calls it, he goes, I'll show you the last one for something. So, he lives in Dallas and everything.
you bought it, right?
Yeah, I bought it.
Oh, okay, good.
Oh,
I went,
On Wednesday to Dallas, stay one day, watch the games. Everybody.
awesome. I went, the last time the World Cup was here, I went with my folks and, with my dad and, it was a lot of fun. It was great. But
Which one
now,
did you go to?
was it Senegal maybe? God, it was so long. It was in the 90s. Like 94 maybe?
I was 11 years old when I watched that.
Damn, I'm old.
Yeah,
I was
I went to, you know, the guy.
17, I
I
think.
did the own goal, the Colombian basketball, how about that Yankee?
Wow.
Yeah,
No kidding.
I went to all the Columbia games, because they had 2 games in LA, and then the last one was in, San Francisco.
Wow.
And I was bummed, so I didn't get to go party, so what we did is we went to Vegas, nothing there, we went to Vegas other than family. And the guys that I went with, the older guys, the guys are like 18, 19, and then their parents. And they were like, hey, we're the Colombian national, this is before the internet. And you think, Colombian national, and the guy, my, what do you call it, one of my neighbor, he was like, he looked like a coach, he's like, oh, coach.
You can't do that anymore.
Yeah,
Yeah. That's awesome.
That was cool. So, yeah, I'm gonna take my wife on Sunday.
You know, the thing is that the prices in Mexico are a lot more reasonable so that people can actually go to the game instead of here, only wealthy people will go because it just is, unless you're that lucky to hit the lottery, but
I got like
really.
the guy that sold me the ticket. He was my old boss. His friend was one of the guys that brought the World Cup. He worked for NRG, so they actually, so what he did is he had the first package of the tickets.
Wow.
So he couldn't get it for free. He just,
Sure.
I could only sell you that people value and get your tickets. You know, the guy, my old boss paid like 1,600. He won all 7 games. He was like, he's like, I don't want to make my money back. I think there's love. I just want to give him something.
Oh, that's nice.
So he's like, I'll phone up with a 5 grand piece. So
Right.
that's all I got. So
Yeah, I pay, you know.
yeah, I paid that. So but I took my wife and we went to San Diego and watched a country in San Diego. So that's the Columbia. So
That's great.
all right, Judge.
Great to see you.
Good to see you. Hopefully I get another case. I still need to first have my first key. I haven't had one yet. I'm trying to get one.
Eventually you will, you know, but I'll tell you, the only thing I can is, you know, when I first became a lawyer, I did the field sobriety test just like the officers did. I did the breath testing just like the officers did. So I knew when I went to trial what I was getting into because I've tried cases and I've seen people try them where I was like, really?
Yes.
So, yeah, no. And so, you know,
One thing I do sometimes, I'll look at cases, we need an expert in how to deal with sobriety tests. I'm not higher in my own cases. I read it, I get the reports and I'm like, I didn't even do this. If you could read the manual 1,000 times, right? There's just things that you know, like, I'm like, oh.
yeah, you know, the more you try, the more you learn, really. So, yeah, you know, the thing, but Roy, also, if you watch a lot of these people, just go watch a trial, you know, watch the cross. You know, I live stream it as well, so you can hear it.
Yeah.
You know, I think we're trying a case next week, right? Oh, no, damn it, it fell through.
You might please, goodness is moving in later today, to talk about it.
Oh, well, there you go.
Very good, yeah.
Okay, I'll let you know next time though, that way, yeah.
It'd be good to watch. Because
Yeah,
I'm
yeah, yeah.
bored and I'm starting to see issue spots and I'm like, oh, those trial issues, so.
Yeah.
So.
Okay, great to see you. Hey, Mr. Leonard, good morning.
Here on,
Oh, I saw your other half here earlier.
you know, he's been floating around.
We won't hold it against
Can't
you.
believe the thing he said.
Okay.
Yeah, well, someone else saw that.
The other day, I was like, huh?
When I wear my contacts, it's gonna be worse.
I can tell you guys.
I mean, the pinky ring. The pinky ring.
You have different
Really?
styles.
That's usually.
Well, now we know, the pinky ring.
That's the best I can do. I do have a gentleman in the back, Judge.
Okay.
Torres.
Torres. Oh, right, Mr. Torres.
Yes, we did do a T-RAS after the last one because you wanted to see what that said. You had, strong feelings toward possible Y-max data.
What do you think?
It recommended the high risk DWI case load with increments within housing.
Okay. That means that the problem is though, he does all that out on his own. How's he gonna be able to pay for it?
Well, we definitely.
We can apply for TAP funding.
For IOP and SOP, very probably about it.
Is she here for Mr. Torres? Ms. Leonard? No.
Oh, no.
Oh, she's on the dot. Okay. What do you think?
Judge, I told him I'm okay with it. It is a second, so he would have to do additional 5 days in there. And then worst case, we could always extend his probation. If he needs more time or funding or anything like that. But basically T-RAS and him getting the help that we get last time, if he's got time, it might be a better.
Do we know 100% they'll qualify for TAP funding or not?
He should because of his age and I don't think he was working right.
Yeah, he's a mobile mechanic. He's got his own thing.
You said housing. How does that work?
So we'll put him with the resource counselor.
Is it like a sober living? No? He goes back home?
He'll go back home, but he'll be matched with like a counselor who will help him, kind of one-on-one with housing,
Edge,
employment.
do you mind bringing out Mr. Torres? Yeah, please. Yeah. Did you say Linton? Yeah, okay.
He said he's living with his mom, and he goes there only a few days a week and then couch serves for the rest of the day, so I'm not sure.
That's not good. That's the problem is there's no stable living. And that's, you're gonna end up wherever you end up. If you end up on someone who's all whacked,
Do you know that I can at least speak to his mom? We've had several conversations. She just can't forward it on, but our conversation.
Do you know if she'll take him full time?
Not asked her that question.
How's jail?
But
Good. That makes me very happy. It's supposed to. When you you're running a prison, Mr. Torres. You're not walking. You're running a prison. Everything that we've done to try to reach to you, to try to make better decisions, hasn't worked. We did a TRAS because I just don't know how to go forward with you. You have a lot of violent history. You have history that's I just don't know how to go forward. The recommendation now is to
Domestic, I'm sorry, the high-risk DWI caseload, with anger management and appropriate housing.
normally, what I would have figured is an inpatient treatment facility. Because with your history, with the DWIs and everything, that's what and now with this new DWI and bond violations on top of it, I would have figured that they would have recommended inpatient, meaning that you're in the jail for about 9 months to a year and a half, going through treatment to learn how to live, act when you're out in the free world, so that this path of destruction stops. Because that's, you may not think it's a big deal, but really, Your next step, you're looking at 10 years in prison. Where are you going to go from here if we let you out? Where are you going to live? Couch surfing's not it. That's not the right, that can't be. Will your mom take you? Will your mom take you?
I have somewhere to stay.
Why not mom?
My mom stays with my sister.
Your sister won't let you stay there?
She will, but I already have somewhere to stay.
Where?
To be, like, if I'm being incarcerated, I have, somewhere to stay.
Where?
With my girlfriend. We've been dating for a month, and, before I got arrested, we were supposed to go in on a lease for an apartment, they're like, but she's secured the apartment, I'm just gonna go to my end, but I was really riding on my license for employment, because that's what I do in the world. I work on vehicles. I have my own company that's for the most part solidified. I just make mistakes sometimes.
There's no mistakes. They're choices. They're either good choices or they're bad. There's no mistake. If you go out there and you drink to your heart's content and you go out and you kill someone, that's not a mistake. It's a choice, and a very bad one at that. What we're trying to prevent is a choice that carries a 50-year sentence. You know, right now, you're still in misdemeanor land, but you're close to graduating to felony court. I mean, really, with everything that we have now, every next charge will land you in felony court, whether it's a DWI, whether it's an assault, whether it's a violation of a protective order, everything. If you pick up another one, will land you in felony court, where you're looking at 10 years in prison. I don't know about girlfriend, really. You know, you're a product of your environment, Mr. Torres. If your girlfriend likes to party and you're with us and you're either on probation or however it is, either just on bond, if you're in that environment, it's hard to say no.
It's not that type of environment, and I want to stay sober. Have kids.
Dang, you got kids?
Yeah.
You're a kid yourself, man. How old are you?
25.
How many kids you got?
2.
You want your kid to be like you?
No, definitely not.
It's going to be. No matter what you say, no matter what you do, the apple never falls far from the tree. Because if your kid sees you in and out of jail, they're going to think that that's okay. Well, my dad was like that. All right. No big deal. I promise you, I see it day in, day out. I see dad, and then I see son. And what the plan is now is this treatment program on the outside. I can try to pay for as much as I can. I can't pay for everything,
Right.
but I can try to pay for as much as I can. But I'm going to give you a heads up that if you're out there, the next attempt, I'm not letting you go. We're going to achieve this, and we are not going to fail you. So we're either going to do it the easy way or we're going to do it the hard way. The easy way is us allowing you to try to attempt this. If not, okay, the next time we'll be impatient. You understand? And there, no apartment, no dog, no grandma, because you could be really in there for up to a year and a half. Do you understand?
Yes,
That means no using alcohol, No using illegal drugs. They're going to test you twice a month. So we know that you're not using. Does he have a license?
Need my license, bro.
I understand, but everything, I get it, but you have to do it the right way.
Right.
Life rewards you when you do things the right way. If you go out there and you drive on a suspended license,
Not eligible, Your Honor.
it's suspended at this moment.
Yes, sir, suspended till June, I think yesterday it expired, or the tech,
Hey, what?
it expired, the suspension expires 6/10/2026.
Really? So he can get it back?
Yes.
And technically right now, I've requested an ALR hearing currently.
That's nice. Good job, Mr. Leonard. Not a lot of people do that.
Hopefully,
Good job.
it'll stay clear.
Um,
We should have that hearing yet.
So you can't just drive though. I'll let him advise you on what you need to do to get your license back. But this is a second DWI. You will have to have an interlock in whatever car you drive. You can't just drive. You need an interlock because it's a second offense. So don't just drive. Don't take your girlfriend's car out to go get groceries because you got to take your dog to go do something. You can't. You have to have an interlock on any car you drive. You understand?
Yes, Your Honor.
You make this work.
Yes, Your Honor.
I mean, you have to.
I have to.
Otherwise, we're doing it the other way. You understand?
Yes, sir.
Okay. I'm down with you if you guys are down with it as well. So we can do it now or we can do it whenever you want.
I know.
Or you guys talk and tell me what you want to do.
We used to do the 5 days, so,
Okay.
We're doing it now, right, so we can get us 5 days out of the way.
Okay.
Appreciate it.
Yeah.
Thank you
Yeah.
very much, Judge.
All right.
Appreciate it.
Hey, if you have any issues, come back, talk to us. The worst possible thing you can do is just take off.
Yes, sir.
Pick up a new case, drive without a license, because I'm telling you, you understand.
Yes, Your Honor.
Okay. Victoria. Listen. Oh, I know she got here real late, huh? Garcia?
Wait, can you get the knowledge for the plea? That's what happened today?
Oh, yes. Is it Watson?
Yeah, those are the only two that I know of.
I mean, we can put it on for Monday. It's not, I mean, he came here, she got here, what, 11 o'clock? Or 12 o'clock? Or you have court. Stop, just, you have a lawyer. I can't talk to you, man. Wow, hey. Picked up a burger hat. Mr. Carruthers. Good morning, sir.
Judge.
Hey, what's up, man?
How are you?
What's new?
So we, I don't know if 88 Nakti has talked to you about this, but we have a case set for trial on Wednesday. On the 16th is for Timothy Williams. I have a cause number for you.
What is it?
2590142.
Okay.
Yes, Judge. So I actually wanted to, before Wednesday, move for a continuance, and I've got a couple reasons why. It's a case from November.
Before?
No, this is our first trial setting, and we were anticipating some a tox report, but it looks like they do not have it. And we got another offer today, so we would review that, kind of eval the case.
Yeah, I'm down with the deferred if that's what you want.
So I spoke to my client. He told me that he wanted to wait. And so, because we're still set for trial, so for one, he has to, I guess, speak with his wife because they're sharing cars, and we have, I think we're evaluating whether or not we want to take the deferred. Because like I said, there is no,
I mean, you got to tell me before next week though.
right. So I was trying to move for continuance now. That way we're not waiting on Wednesday.
No. But look, I don't want to play games, man. If he wants to take the deferred, then take the deferred. If not, we'll keep it on the trial track, but I'm not going to take any more offers. This isn't a game where, no. If you want to go to trial, great, let's go to trial. But I don't want to, okay, well then we're going to do another continuance and then we're going to plead on the day of trial. No.
So we just got the deferred offer today, like 20 minutes ago.
I understand. I'm going to give you until early next week.
Okay.
Yeah, for sure. But what the heck is up with the lab?
I'm not sure you're like.
I'm not, no. I mean, we're 7 to 8 months in this case. And how the hell do we not have the lab back? Really? We're set for trial. They still don't have the damn lab back. I mean, how?
We did get a preliminary alcohol report. It's below the limit.
Okay.
There's additional testing and we don't have that response back yet.
When did you send that in?
They usually send it in once they're done with their ethanol is what they do first and then
Sure.
and then they send it out to.
But then that takes another 6 months to a year. I'm not going to wait. When did you guys send that out?
That's the reason why we did it without it, Judge, and we determined that we can go forward.
Yeah, then, okay,
And that's what
great.
we offer the card. Yeah.
Got it. But if the labs are not back, I'm going to have a hard time letting it in. I'm telling you now, really, it's just not fair.
Yeah, I understand.
So Ixnay on the lab A, Mr. Carruthers.
Yes, sir.
With that in mind, you guys need to make a decision on what you want to do. Okay? So we'll do this. File your motion for continuance, but I need you to speak to your guy. If he wants to go to trial, then we will go to trial. I will grant your one continuance. I'm not going to give you another one, but if he rejects the state's offer now, we will go to trial and I will not accept anything else after this time.
Okay.
Okay?
Understood, Judge.
All that
I will file my
considered,
motion right now.
just let me know before Wednesday.
Okay.
Scheduling, so this is where we doing for Dyer on Tuesday.
Yeah. Yeah, so I guess Monday, at the latest Tuesday, because I have to get a panel, right? Because we would do voir dire on Tuesday, start testimony on Wednesday. So, let me know, I guess, on Monday, what you guys want to do.
Will do.
Okay, Mr. Carruthers.
Thank you, Judge.
Have fun,
May I
man.
be excused?
You got it. See you Monday.
Yes, sir.
Yeah, I mean, it's just, but regardless, I mean, she picked up a bird half, I got to do some conditions, man. Yeah, let's do it. Come on.
All right.
Just take a seat. We're waiting for your lawyer, ma'am.
So it'll be your first time.
2501.
Bottom of 7 is Jackson, 2 bonds posted, Belgium.
5002.
Okay.
And yes on the BL. Okay.
So if you cannot show up, let this happen. Then the attorney will bring the bond violation to the receipt. If you don't show up, then that's.
And so.
So. The work is on this, you have to show. The reason that you're in a coma in the hospital. But this must be really on and that they have. Yeah. But representative, we can do the work experience now. But you have to show that, I already sent you. Are you on the see that?
No.
They never do things that I did. We found out, if share and send it to us, that way the everything's up on it, you know. Do you have any? Yeah.
No.
If we not allowed to check.
Okay. Who's next?
Top of 13, go to your first time.
2501.
And bottom of 15, go to your two boxes.
5002.
So any.
Mercy.
Any questions? If you have any additional questions, you can take it and tell your mom, you can also. Please, I was saying, you understood the thing?
Okay.
Top of 19, I know the council approach, but I don't know how.
5001.
Who's taking in?
Yeah, he's taken in.
Bottom of 19, go to appear first time.
2501.
Bottom of 20, go to appear, as it to open one. This was the one that he had to re.
Oh, right. What is, let me see what I did over there. 2501.
Bottom of 22 has called for your multiple times. He lives in Louisiana, I think he said, or Ohio, whatever. He can't come in because he's working and he's on probation. And
He's on probation, what?
for, so his last of his probation is for this July. So he's basically asking for a long.
But
Yeah.
no, SFBF Monday. If he fails to appear on Monday, it gets revoked. Hey, did you hear that? You hear that? That was on Turner.
That's it, Judge. The last one is that we is back.
Okay.
Well, the animals, and it's all like, okay, then you see that, not the ones that are being was left. They have to ask all of them, since they eat, they want to be friend, if you probably check them, that's why you really have to check them every single day. If it's something that you do, maybe again, well, I do is that it's changing the school, so anytime you always have school, thanks, check, I found that one thing, it was already beyond.
Is that what it says?
Yeah. You don't put them in early 3 months, and then we don't go to them. Was there any other to me?
Understanding is.
Just check it if you need all the application. You would need to set an alarm just to, wake up, send that text confirm, and then, so anyone can go and see if we just need that confirmation.
You guys put a charging instrument complaint. Did they forget to put a 2B instead? Why, who, how, and why? Who? Cats.com? Hey, can I have you look at something, please?
Like you're talking about?
Yeah. Did they forget to put a Q in there, you think? Or a 2B?
It's not a two.
Right.
Done by Christopher Sackett. Maybe reach out to him and see why. Because I think the clerks, in another department knew that they did about seven.
But wouldn't they, it would be a 2B, not just a complaint, right? Because how can I find, I mean, he's an ABA. Yeah. They can't, I don't think they can reach out to the ADA. Can I give you guys a cost number, please? It's 262-4731. Yeah. So Mr. Sackett, who works with you guys, just put the complaint in my queue for me to sign. But normally there would be a 2B or something so I could find PC, right?
Yes. I mean, it looks like the.
Or I guess if you want to read.
It was part of the information drive, they have a warrant.
And you'll just, email
I'm not sure if it was maybe trying to let you know that she picked up the law and she got on bond. On a case in your court.
It
just shows it was followed with information today, so just, she had a quote today.
Oh, I just issued a warrant on her.
Yes.
She picked up a new case.
Yes, I think you wanted to let you know that she picked up a new case, maybe.
Huh.
Oh.
Oh, okay. Okay.
I have a bunch of DAs here. You have a lawyer. If you say something, you could be hurting your case. That's why. It's not because I don't want to hear you. I just trying to protect you from yourself.
Maybe I'm saying it won't not here.
But regardless, you have a lawyer. I'm not allowed to talk to you without a lawyer. Did you reach out to Zane again?
I did.
You did? We've reached out to him multiple times. Your lawyer was here earlier looking for you, but you came late. I understand. The excuses just don't, he was here earlier. What docket starts at 8:30. You're supposed to be here at 8:30, not 9:01, not 10:35. Right, even if you're abducted by aliens, I get it. Nevertheless, you're still supposed to be here at 8:30 or 9 o'clock because that's when the lawyers get here. Because you're here late, just because you're here late, they already left. We've tried to get a hold of him, but they're probably out doing other things and they figured that you weren't going to come. So the only thing we can do is can set your case for Monday. You got to come back on Monday at 8:30 in the morning. Don't come at 9:01. Don't come at 10:32. If you come late again and your lawyer comes and takes off again, then I'm going to set you for Tuesday. And then I'm gonna set you for Wednesday. You understand?
If someone goes school outside and one part,
Um,
we don't wait to see until we're done? Amazing.
yeah, we have one more plea coming up in about 5 minutes. We'll wait at the end of that, then we're done. At that point, we're gonna break. If he's not here, then we'll reset you to Monday. Any conditions you guys want that you feel that's appropriate? I don't even know. Like.
Yes. Okay. So Judge, it looks like, Bonnie gave her bond position.
Are you happy with it? Sufficient?
Yes, Judge, I think it's a good position.
Okay.
Judge. Never feel good about this.
The only other question is for that is, you think that's this side, the word of the process weeks.
But that's, she was gonna file another writ. This is not a new writ.
No, it's not.
This is the one that we dealt with.
Mhm.
Okay.
Yes.
All right.
Same.
Are they bringing them out? Yes, you can bring them out. Okay.
When they bring pregnant, but that's really good. These always work with their long term somebody's children.
Yes, ma'am.
That's your children.
Yes, ma'am.
And you get your advice on that new life.
Or Mr. Torres, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 1 year. As part of this, should be 18 months? No? What is the normal? This is a specialized caseload.
No.
It's
It's just
not?
a regular caseload. But with the high risk caseload, you'll report twice a month.
So it's a 1 year Harris County Jail sentence to be probated for 1 year. What that means is that if you violate this probation, you are looking at an entire year in jail, 365 days in jail. If you test positive for drugs, illegal drugs, if you test positive for alcohol, if you do not have a guardian interlock, if you drive on a suspended license, if you don't do your classes on time, if you get kicked out of your classes, if you pick up a new case, you must maintain full-time employment. Do you understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. And I'm telling you, if you violate this agreement, one of the things I can do is I can amend and alter these bond conditions to look at inpatient treatment. Do you understand?
Yes, Your Honor.
Can you get this done, Mr. Torres?
Yes, Your Honor.
How do you plead to the offense of driving while intoxicated, second offense?
Guilty.
I'm going to find you guilty. I'm going to sentence you to this agreement. You need to understand one more thing. Your record. Every time you get pulled over, it does.
Yeah.
It does. And the thing is there, when you get in contact with the laws, no matter whose fault it is, no matter what happened, when they start looking you up to see who they're dealing with, you think that you're going to get a benefit of the doubt.
No.
I don't know. Maybe yes, maybe no. But I will tell you this, with your record, if you get pulled over and you smell like alcohol or you smell like dope, you don't come to us anymore. You will be heading to felony court. So for the rest of your damn life, if you have a sip of alcohol, don't get into a car. If you thought this was bad, wait till you get to felony court. So the conditions are a TRAS, which you have already done, so you don't have to do it again. One victim impact panel, a DWI repeat offender education class. No drugs, alcohol, must maintain a guardian interlock, substance abuse treatment, no breath test refusal. If you were pulled over, an officer asks you to submit a breath test while you're on probation, you must do it. And 50 hours of community service.
And you're kind of regarding the community service, there was a limitation, I don't know if you saw that by the chief, that would be waived with,
What I normally do is a parenting class. If they get a parenting class done, then I'm willing to waive because homeboy's got 2 young children. If you get a parenting class done, then I'll waive the community service for you, okay? Just the apple never falls far from the tree. Your kids, no matter if they're a girl or if they're a boy, you got a girl?
2 girls.
They're going to be exactly like you. Imagine you as a girl. It's going to happen, Mr. Torres. If you love those little girls that you have, do them a service and be a stand-up guy. Because I'm telling you, there's no hell on earth like having teenage daughters that are on hell on. I'm telling you, I have teenage daughters now. And if they're out of control, your life will, it will be a living hell. They're going to be just like you. You understand?
Yes, Your Honor.
All right. Did you say guilty? How do you plead? Guilty or not guilty? I'm going to find you guilty. I'm going to send you the agreement. We're going to waive all your fees as much as you can. We're going to try to get you TAP funding so you don't have to pay for the IOP, the intensive outpatient and the outpatient treatment program that you're going to have to do. Show up, get it done, because you don't want to graduate to felony court. All right. Good luck, Mr. All right. Thanks, guys. Oh, I have to suspend 1 year driver license suspension. I have to suspend your license. If you're doing well on the probation, we could talk about an occupational license so that you can drive. You can't, I have to suspend your license as a second DWI. I have to. The law is a mandatory suspension. I'm going to do it for the minimum, but if you're doing well, we can talk about an occupational license so that it allows you to drive for work. Don't start driving because you can't. If you drive, you're in direct violation. I'm going to be pissed. Do you understand?
Yes, Your Honor. What's the minimum?
A year. But if you're doing well, we'll talk about an occupational license so that you can work and drive legally, you know? That it sucks looking over your back the whole time. It really does. All right, good luck, bud. Thanks, Mr. Leonard. Okay. Yeah, just reset it to Monday. It's 12:30 and he's not appeared and he was here early.
Okay. Ms. Garcia, come on up. All right, go ahead and sign the release. Yeah, that's what he said. It is better.
But absolutely, the cases, honestly, did you get that case? Okay, it's what I'm.
All right, here you go. Free to go.
Yes. I did, and the next thing I did, you did your job. 7 in the morning, finished at 1. And then we could say, you did your job, so I did, went back, it was crazy. One of the first one lost the 7.
So you these guys for all day, but not to do.
Oh, yeah.
Yeah, you have.
There's a hell of a. Yeah. I like that. Felt great weekend.
Yes.
Bye.
Go to another one around here.
That's it? Are we done? Okay, guys, we're done.
Thank you, Judge.